I'm Ann McGinnis. I'm an attorney at Schoeneck King. It's so nice to be here. Different place, but we're all together still, and that's what matters, right? And I'm so happy to see all of you. The last time that we were together, I was very, very pregnant. And what all of you don't know is that the night before, I almost had to go into labor, but I was able to hold off. I was like, I just need a couple of days, and I made it. And I did the seminar, and the baby was born the next week, and his name is Joseph. He's very happy and healthy, and it's been great. So I had my maternity leave, and thank you to all of you who were so gracious, and to my colleagues who were so gracious during that, because I enjoyed my leave so much and came back, and now I'm at Bond. So, lots of changes, but changes for the good. I'm here today with Jeff White, who all of you know, and one of my new colleagues, Kate Reed, who is one of our colleagues at Bond that we joined. And we're going to be covering a number of special education topics today. We have a lot to cover, so we're going to kind of push through. But of course, if you have any questions, let us know. We do have a whole bunch of people joining us by webinar, so hello to you. I hope you can hear us. If not, put something in the chat box and somebody will let me know. If you ask questions, I'm going to have to repeat them into the microphone so that they can hear them, just so you know. So that's how we're going to do that. All right, today we're going to be talking about a few different topics. We're going to start off with restraint, seclusion, and timeout, which we did talk about in the fall, but we're talking about it again because the state has guidance documents since then, and that has cleared up some questions. So we're going to cover those. We're going to talk about station determination reviews. This is a hot topic. We're getting lots of calls from all of you on those, and the state is certainly having some pretty high expectations of districts, so we're going to cover that. Then we're going to cover classification considerations for OHI versus emotional disability, another hot topic. We're going to finish it off with all things consent, which will be a very helpful resource for all of you, because it's like a one-stop shopping for any question you might have for consent. So we're going to start with restraint, seclusion, and timeout. We know that the regulations changed last summer around this with some specific requirements around restraint, seclusion, and timeout. And we're expecting them to come out because the Federal Department of Education released some guidance around that a few years ago. And these new requirements in New York State now align with those requirements from the federal government. And under these updated regulations, it prohibits the use of corporal punishment, aversives, and prone restraint, and new requirements around timeout and physical restraints. And now there's also requirements that everybody has a policy around this. It used to be we only needed a policy if you're going to be using restrictions, but now every district needs a policy. So think about that for your own district if you haven't adopted a policy yet. New requirements around documentation, parent notification, debriefing, and then reporting to the state. Here's the two guidance documents that have come out since the regulations were updated. We're going to summarize those today, but if you want to look them up, you can Google and you will find those. And under the regulations, a physical restraint is defined as a personal restriction that immobilizes or reduces the ability of a student to move their arms, legs, body, or head freely. It does not apply to a physical escort. So this is something that is different. A physical escort is brief physical contact or redirection to promote student safety, calm or comfort a student, prompt or guide a student when teaching a skill or assisting a student in completing a task or for other similar purposes. So a lot of you used TCIS, and back in the old days when I was trained in that more than 10 years ago, there was a physical escort component of that, which I don't think they teach anymore, right, Becky? Where that was considered a restraint, where you would essentially physically escort a student out of the room or to a safer place. And so we have not done that, and we should not do that. But we are able to kind of guide a student. So that would not count as a physical restraint if we're kind of gently guiding a student with a hand on the shoulder, maybe, or if we're doing hand over hand teaching through like an ABA technique or something like that. Those types of things would not be considered physical restraint. Prone restraint is when a student is in the face down position. We already weren't supposed to be doing prone restraint under the different programs that teach us how to safely physically restrain a student. It's very dangerous. And now it's not required by law as well. Oh, and I'm sorry, the physical escort is what I was describing, which is the temporary touching or holding of the hand, wrist, arm, or shoulder for purpose of inducing a student who's acting out to walk to a safe location. That's the exception I was talking about before. Now, we're not picking up a kid and dragging them, right? That would not be okay. But if we're gently guiding them to a safe location, that would not be considered impermissible. Timeout is a behavior management technique that's the monitored separation of a student in a non-locked setting, implemented for the purpose of de-escalating, regaining control, and preparing the student to meet expectations to return to their education program. That's a pretty similar definition to what timeout was before, but we have some more clarification around what is and is not timeout. The student has to be returned to their educational program as soon as they have safely de-escalated and regained control, and it has to be used in conjunction with a BIP, except for situations that pose an immediate concern for the physical safety of the student or others. So we should only be using timeout if it's part of their BIP unless it's an emergency, unforeseen situation. If you're using timeout with a student a lot, more than once or twice, that's probably an indication that it's time to do an FBA and consider a BIP, because that's no longer an unforeseen situation if it becomes part of an intervention that we're using with the student. Timeout is not a student-initiated or student-requested break. We used to get this question all the time. What if the student puts themselves in timeout? Do we count that? And under the old regs, we would say, well, probably, because it doesn't say that you don't. But now we know explicitly you don't need to count that if the student is initiating or requesting a break. Timeout is also, and this is important, it is not a room or space that has tools or activities to assist the student to calm, or the use of such intervention strategies consistent with the student's BIP. So this is like a sensory room. That's something else that we didn't know. We used to have conversations about this with other seminars. Would a sensory room count as a timeout? And under how broad the old and vague the old definition was, it was unclear, but it seemed like probably. Now we know it doesn't. So if it's really for that purpose where interventions are being employed, if it's being used as part of a BIP, it would not be a timeout room. And it's not a teacher removal and school suspension or other appropriate disciplinary action. So it's discipline under the code of conduct. That's not. SCB has released guidance on calming spaces, something that we really needed. We've seen calming spaces on IEPs and even 504 plans for years, and I've advised against it because it sounds like timeout, but now SCB is saying it's okay. So it's good to have that clarification. A calming space cannot be locked or be used to isolate the student as a form of punishment. Timeout also can't be for those purposes. The intention is that it's used as a temporary intervention strategy, and students return to the class or program as soon as they're able, ready to learn, and missing as little instruction as possible. And it's important that the district monitors the use of the strategy, because routine use of this could warrant an FBA and perhaps a BIP. Some other limitations: timeout has to be used in conjunction with a BIP, like we said, unless it's an immediate concern. I would say an unforeseen immediate concern for physical safety. And a physical restraint can only be used in a situation where physical force is needed to prevent imminent danger of serious physical harm to the student or others. So it used to be under the regulations that we could use restraint if a student was engaging in behaviors that place the student or others at risk of physical injury. That's still true. But it also used to be that we could use physical restraint to prevent property destruction. Now the regulations have been updated to say we can only use it to prevent property destruction if there's reason to believe that would result in injury. So it's always injury. It's always somebody is at risk of injury that we can use physical restraint. When we're doing physical restraint, we also have to think about the least restrictive restraint that can be used. We have to immediately discontinue it as soon as the imminent danger is resolved. It cannot be used in a way that restricts the student's ability to breathe or communicate or cause harm. It can't be a planned intervention on IEPs or BIPs or 504 plans. We cannot use it with preschool students who are attending an OCFS licensed program. Only staff who are trained in accordance with the regulations, can use physical restraint with students. And after the student is restrained, the student must be evaluated by the nurse. And it has to document the nurse has to document any injuries, including any staff injuries if there were any. Mechanical restraints are prohibited. That's not new. An exception to that would be a vehicle safety restraint. So like a harness that is permissible to use to keep a student safe. It should be a CSE decision if a student's going to be using some kind of harness, and it should be on their IEP. Sometimes I see transportation departments kind of make that decision independently. It's important that that goes through CSE. This is a big one. There was just a guidance document released last month that clarified an SRO, a school resource officer's role in all of this. And they made it clear that an SRO can only handcuff a student if it's part of an arrest. So if they're deciding in their role as a police officer that they're going to arrest the student, then they can handcuff the student. But absent that, it is not permissible to handcuff a student in school. It is considered an impermissible that would be a mechanical restraint. And not only can they only do it when carrying out an arrest, it has to be necessary for the safety of the student and others. So those two considerations have to be present. Okay, like I said, all districts should either be updating or enacting policies and procedures around this under the new regulations. If you haven't already, it should be, at the top of your list of things to do, because we're supposed to do that as of when the regulations changed over the summer. And the policy and procedures also have to include factors that may precipitate the use of timeout or physical restraint, and developmentally appropriate time limitations for those as well. So here are some examples of precipitating factors for physical restraint, just examples. If the student's becoming physically aggressive toward others, engaging in elopement behaviors that are likely to place the student or others at risk of harm. So a student who's eloping from the classroom and maybe just walking around the building, but not at risk of harm, not putting anybody at risk of harm, that probably wouldn't be a reason to restrain the student. But if the student is running out of the building into traffic, that could be a time that you're going to restrain them, because they would be at risk of harm in that situation. If the student is destroying property in a manner that poses an imminent risk of danger or serious physical harm to the student or others, if the student is engaging in other behaviors that pose an immediate risk of harm to the student or others, and the use of other less restrictive intervention strategies have been unsuccessful. So that's important. We need to consider what we can do to intervene and implement those before we actually restrain the student. We should document that in the documentation as well. So all of our staff should be trained on all of the things they can do to try to de-escalate without putting hands on students. And that should be a last resort option. Some precipitating factors for timeout could be the student becoming physically aggressive, engaging in elopement that places a student or others at risk of harm, engaging in other behaviors that pose imminent risk of harm, and the use of other less restrictive intervention strategies have been or would be unsuccessful. So same criteria really for both. Time limitations. Physical restraint can only be used when there's imminent danger of serious physical harm to the student or others. As soon as that passes, the physical restraint needs to end. And for timeout, the amount of timeout that's permissible varies depending on the student's situation. Age, grade, developmental level, individual needs, and the behavior intervention plan are all considered as part of that. And they should only spend as much time and timeout as needed for them to de-escalate, regain control, and return to the educational program, or they no longer pose a concern for the physical safety of themselves or others. There's very specific documentation requirements around these interventions, and they have to be completed for every incident. So it's important that your district or your school has forms that staff are trained on, that they know how to complete, and that these forms comply with the regs. If you had forms before, which you should have, they need to be updated because there are new requirements if you haven't already updated them this year. So the forms have to include the name and the date of birth of the student, the setting and location of the incident, the name of the staff who participated in the implementation, that basically the staff who were present. I've had some districts question that because staff don't necessarily want to have their names on there, but it is required under the law that we include the names of the staff. A description of the incident, including the duration, and for physical restraint, the type of restraint used. You have to identify if the student has an IEP, a Section 504 plan, or a BIP. All positive proactive intervention strategies that were used prior to timeout or physical restraint, and if such strategies were in line with any applicable BIPs. So we have to explicitly document all of those less restrictive interventions that we employed before we did one of these. Details of any injuries to the student or staff, documenting that the student was evaluated by the school nurse, and the date and method of notification to parents and guardians, and whether a meeting was held. So we are required now to notify parents on the same day that these interventions are used. And if we are not able to reach the parents, we have to document all of our attempts to contact them. And we also have to notify the CSE that we were unable to reach them and notify them of our attempts to reach them. And the notification also has to include an offer to the parent to meet regarding the incident. Another requirement is that the parents have to be provided with a copy of the documentation of the incident within 3 school days. That's new. So whatever we write on that form, we have to give the parents a copy of that form within 3 school days. When do we create a record? Any instance of physical restraint or timeout has to be documented. And also any allegations regarding prohibited intervention types, like a prone restraint or maybe an aversive intervention, all of that needs to, if there's an allegation that that occurred, that needs to be documented as well. And if there's multiple event records during a day, that would only be created for a student if a new situation occurs involving the same student after the prior event had de-escalated and the student returned to the learning environment, or when a new restraint or intervention response type is used during the event. So an example of that, if during an event, physical restraint is used with a student, and then the situation escalates and then timeout is used, the addition of the timeout would constitute an additional event record beginning with that application. So you would have 2 documents there. You would have the physical restraint and you would have the timeout separate. More information about SROs. Basically, if an SRO is engaging in a physical restraint, they have to comply with all the same requirements that our own staff members have to comply with as far as training, the interventions used, the documentation that's used. All of it is the same. They are an agent of the district, they're part of the team, so we have to follow the same requirements. This is different from when we call the local police to respond to an incident. That's the police coming in as a police officer. But if the SRO is employing a restraint, it's the same requirements. We are required to have annual reporting beginning next school year. And there's a link there for how we can report that. And we have to have procedures in place to collect and report the incident data for students. If you are the district of residence and schools, and whose schools do not report directly to the department by SIRS. So we had a question yesterday. What about if a student is parentally placed in another public school? That public school allows non-resident students in. Who would report that? And I think arguably the public school where the student attends would report it because they're reporting that student on the SIRS requirements. And they would be required to report under the law. But if you have a student placed somewhere where that school is not required to report, then you as the district of residence would have to report that. And then a reminder for documentation review and training, there is a requirement that everybody receives annual training on this. And then any staff that may be employing like a physical restraint has to have specific training on that as well. But everybody has to have general training on timeout and physical restraint on the policies and procedures that the district has developed around that. If there are situations where there's multiple incidents within the same classroom or involving the same staff using these interventions, then the school administration has to address that. So there is a requirement that administration regularly reviews these documents. And I've seen these documents have a sign off for which administrator reviewed it. Probably a good idea to document that. All right. And as far as the annual training for everybody, I just want to make sure I'm clear about this. Policies and procedures for the use of timeout and physical restraint, evidence-based positive proactive strategies, and crisis intervention and prevention procedures and de-escalation techniques. That's for everybody. But then anybody who may be called on to implement timeout or physical restraint have to receive additional evidence-based training and safe and effective developmentally appropriate timeout and physical restraint procedures. So TCIS is an example of that. I'm not plugging TCIS, but that's what I see you guys using the most. And that would be an example of an evidence-based intervention procedure that we can do training on. I've had questions like, what if our staff don't want to be trained on this? Well, they're required at a minimum to be trained on the policies and procedures and proactive strategies, et cetera. But also, they don't get to decide if they're going to be employing physical restraint or not. If that's part of their role within the school, then they would have to be trained on that. That would be part of their job duties. Yes, Linda?
About staff, like clerical staff, office, let's say all staff, but you have no contact, never employee restraint. You have a thought on that?
So the question was from another attorney, what is my thought on if we have clerical who never interact with students, if we should be training them? And I don't think that the regs tell us, right? Which is probably why you brought it up. I think that it says, the regs say everybody. So we're going to interpret that literally. I would say everybody. But you probably don't have to train them on how to implement timeout physical restraint. Other questions? Okay. Hearing none, we're going to talk about manifestations. I'm going to give it away to Jeff, and then Kate is also going to be talking about manifestations. Oh, Kate's going to start us off even better. Do you want this? I don't know that the lapel one is working.
We're cute, so you felt present.
Yeah.
Thank you much. Yeah. Good morning, everybody. I haven't met many of you yet, but I'm looking forward to meeting you soon. My name is Kate Reed. I'm a partner at Schoeneck King. Very excited to have some new partners joining us recently, Anne and Jeff and the rest of their colleagues. It's been wonderful to have them joining our team. I co-chair Schoeneck King's K-12 school practice. And in my practice, I really encompasses the full scope of school district representation, including personnel issues, business office issues, board governance issues. But the subject that is nearest and dearest to my heart is special education. It was the topic that got me into school law in the first instance. And a significant portion of my practice is still special education related. So very nice to meet all of you here. Looking forward to meeting you all one-on-one as well. And looking forward to talking about manifestation determinations. I agree with Anne, we're seeing a lot of enforcement activity in this area. It seems to be certainly a hot button topic for the CEQA audits, for compliance reviews, and as Anne said, the expectations from state ed regarding compliance on MDRs, I think is just getting stricter and stricter. So this is a really timely topic. So we're going to go over the basics and then maybe some of the less basic aspects of MDRs as well as part of this training. So what triggers an MDR is the first question, right? And it's a disciplinary change in placement. The MDR rules are intended to prohibit discrimination, right? That is the kind of basic concept here, that it is a form of discrimination to exclude a student from school based on a manifestation of their disability, if the behavior is a manifestation. So we can think about this from a disability discrimination standpoint. What is prohibited? Part 201 prohibits any disciplinary change of placement. If a student is about to undergo what qualifies as a disciplinary change in placement, then the student is entitled to certain procedural rights under state and federal law. So we have to understand first and foremost what constitutes a disciplinary change of placement. We also need to understand, does a student qualify either as a student with a disability or a student presumed to have a disability for discipline purposes to determine whether or not these MTR rules are applicable. So what is a disciplinary change of placement? I think this is the rule that we like to joke sometimes that legal advice has a half-life, where I feel sometimes, and this is one of these areas where I think there's just consistent confusion regarding when the trigger for an MTR, how many days, what constitutes a disciplinary change of placement, and what is a pattern. So we're going to get into all of that in a little more detail here. A disciplinary change in placement by regulation is any suspension or removal from a student's current educational placement that is either for a period of more than 10 consecutive school days or a period of 10 consecutive days or less if that series of suspensions constitutes a pattern according to the factors in the regulation, which we're going to unpack. An important part of this definition: disciplinary change of placement can encompass more than a formal suspension effective through 3214. There is guidance, there's guidance documents that speak to situations, for instance, where a student is asked, where a parent is asked to come and pick a student up. That in and of itself, it can be a removal from school if it's involuntary, that could still trigger these MDR. So it is broader simply than a suspension under 3214. Any removal from school potentially does trigger these rules. Now, what is a pattern determination? So as we stated earlier, a pattern of non-consecutive suspensions that amount to 10 days in sum can still constitute a disciplinary change of placement. So it is really key for school staff to be able to identify and accurately determine when a pattern of suspensions actually meets that definition of a pattern under state regulation. So the factors that the regulations tell us to consider: does the student's most recent misconduct, is it substantially similar to the behavior that prompted prior suspension? So in other words, are we talking about a similar misconduct, similar behavior? Proximity of the suspensions to each other. And none of these factors are dispositive. In other words, none of these factors are in and of themselves sufficient to rule in or rule out whether or not there's a pattern, but they're all supposed to be considered in totality. So we look at how related are the suspensions in time. Do we have one in September versus the second in June? There's not a lot of temporal proximity there. How long were each of the suspensions in total? How much time has the student actually been removed from school during the school year? And we have an example here as well, which is context is everything. So when you're looking at whether or not there is a pattern or related behavior, think about that question a little more broadly than simply, did incident 1 involve bringing a vape to school and did incident 2 involve bringing a vape to school? That pattern analysis is a little broader. So even though the two incidents may appear to be unconnected, if there were precipitating factors that prompted both of them, that in and of itself can be a trigger for an MTR. So, the example we have here is, think about the context of when the incidents occurred. Did they all occur on the same school day? Did they all occur immediately following a particular type of activity, a particular demand placed on the student, for instance? Those factors in and of themselves could indicate that the misconduct is in fact related, even if the behaviors themselves, in an isolated fashion, look to be a little different. Do in-school suspensions count? The answer is technically no, but the exception kind of swallows the rule here. So tread carefully. What the Office for Special Education Programs from USDOE has opined is that an in-school suspension does not qualify as a disciplinary change of placement unless the program and services provided to that student during the in-school suspension are inconsistent with the IEP. So that becomes sort of the exception that swallows the rule, as I said. In most instances involving an in-school suspension, the services are not going to be mirrored directly in that suspension environment. So if the ratio of staff to students is different, if the qualifications of the staff are different, if the services provided in that setting are different, you are really should be considering those in-school suspensions as part of your pattern analysis. So most common question, I think, and actually I'll ask Jeff and Ann if their experience is the same. How many times do you get asked, do we get to redo after we get to 10 days? Do we get a reset? Right? It's one of the most common MDR questions I get. And I feel like every 6 months or so, I tell people again, no, there's no free get out of jail free card. There's no pass go. You're not collect $200. That's great. Once you've used up your 10 days, you're done for that school year. So the question of when does the 10 days reset? It resets at the beginning of the year. And the simple answer is, and this is where I think all of you probably have frustration when you're interacting with building level staff that will appreciate this distinction. Once you hit that 10-day mark, you are simply prohibited from suspending beyond that without conducting an MDR. There is no reset. When counting the number of days of suspension, 201 also expressly includes partial days in that definition. So that's something to consider as well. I know we had I've seen some kooky configurations and calculations in districts where districts will say, well, they route for 2 hours, so we're going to count that as a 0.2 suspension. No, 201 expressly provides that a partial day qualifies as a day for purposes of the pattern. So schools can and should have a process in place for tracking short-term suspensions so that this pattern analysis is not lost in the shuffle when kids are CSE eligible. So there is no mandate in the regulations regarding who is required to perform that pattern determination. That is left to local decision making. And then finally, as we said, there is a challenge procedure under our due process procedures for a parent to challenge whether or not that pattern analysis is done properly.
Question for you, King, and dealing with the procedures. Question I get a lot is, the student is classified mid-year to the suspensions, before the classification counts. And my answer is they do, because it says annually.
That's a great question.
Yeah.
Yeah. So Jeff's question, he's putting me on the spot. Look at this guy. So what Jeff is asking, what a great question, which is what happens if a kid is classified mid-year and was previously suspended prior to that classification decision? Would you count the suspensions that occurred prior to classification as part of that pattern analysis? My answer is yes, because again, if we go back to the purpose and function of the MDR process, it's to prevent suspended students from conduct the manifestation of their disability. Once we are on notice that student qualifies as a student with disability, I believe that the pattern regulations come into play, and that whole school year will be encompassed within that pattern analysis. So I think, Jeff, your answer is the same. Yeah. And same answer, or do you see it differently?
Same answer. I have a different question.
Oh, Ann has a different question. What's the answer?
It came from. Thank you. Do you want to read it?
Do you want to read it?
Okay, so somebody from home, thank you for your question. We've been told by our hearing officer that they are only looking at each category in our code of conduct for each 10 days to run a manifest. So technically a student can have over 10 days total if we do this. For example, 8 days for health and safety violation and 7 days for insubordination. Hearing officer would say no manifest, but we're technically at 15 days. So something that I've seen happen recently in this area, and this is new to me, is rather than for the pattern determination, some hearing officers are saying to look at like the provision of 3214, like the charges.
That's not a thing.
Right. Rather than the actual misconduct. So, do you see what I'm saying?
Yeah. So I think all three of us are going to have the same answer that that's not a thing. That's my problem. Not a thing. We do not know. So you cannot, and one of the things we're going to talk about also in terms of the suspected of having a disability category, as in most areas of special education law, you have to avoid generalities. Whenever you get into looking at generalities and categories for decision making versus individual student need, you're going down a dangerous path in my opinion. So that in that situation, no, you wouldn't look at categories under the code of conduct. You have to look at the specific behavior in question in conducting that pattern analysis. It could very well be, as we said before, that the two forms of misconduct, trigger completely different processes under the code of conduct, and they fall in different categories in the code of conduct. but they nonetheless would be considered a pattern under the special ed laws. So when must the MDR take place? The regulations state immediately if possible, no later than 10 days after the decision to suspend is made. Now, and again, I'm curious about my colleagues' take on this. I often get the question, listen, Kate, we have suspended 10 days. Principal is imposing a 5-day suspension beyond, those 10 days for conduct that we believe constitutes a pattern. Can the principal impose that suspension and then hold the MDR 10 days later? My answer is no, because once you hit those 10 days, you have the definition of a disciplinary change in placement has been satisfied, and any suspension beyond that day requires an MDR and finding of no nexus in order to impose that suspension. Jeff, do you see it the same way? This is so great when we all agree, isn't it?
Because the rule, there's a reference to you have 10 days to do rules. That's one rule. If you have up to 10 days to have the manifestation meeting. On the flip side, you can't impose a disciplinary change of place without a nexus. If we interpreted that reg broadly, these rules would have no, they would be, they can't be. And this has to be within reference to like, a long-term suspension where you have zero, we started with 0, and then you can wait up to day 10 somehow, if the superintendent is strong, which poses another issue, which we're gonna bring up in a second too. But it can't be. Now, sometimes from a practical standpoint, we can't do it. We go over it. And we shouldn't do it, but we do it anyway because you have no choice. Cross your fingers that you find no nexus and no harm, no foul. But technically, if you have this a couple of days late, find nexus, I mean, you're going to owe compensatory services to the student.
The
so,
kid should be in school pending that determination.
And sometimes what we'll do is it's very unusual, but technically the principal should write up the notice of suspension, so we cannot impose the suspension until after the nexus. And this is not sound discipline practice. You get it. Because when we learn law school, like you need for deterrence, you need an immediate impact. Unfortunately, these are the rules.
No specific deterrence, no general deterrent.
So we're going to have another timeliness issue too. We'll talk about when we get into the superintendent's hearings. But I'm going to return this to Kate.
Thanks, Jeff. Great. So let's talk about the meeting invitation for a minute here too, because curious if Jeff and Ann have had the same experience, but in my experience, in the last year and a half, this has been a hot topic for SQL audit, is the prior written notices for MDRs. I think a lot of districts have been in the practice of sending PWN after the fact for MDR determinations, which is fine, but there is a actual, this is one of these few places in law where the prior part of prior written notice actually does apply. It's one of the most misnamed, frankly, instruments in the regulations. But what the regulations state is that a district must provide notice of the MDR meeting no less than 5 days before the meeting in order to comply with other applicable timelines. This is required prior notice, again, prior to meeting. The MDR team, however, need not be a full CSE. The requirements of mandated participants is slightly different. The following individuals are permitted to attend an MDR by regulation: a representative of the school district knowledgeable about the student and the interpretation of information about child behavior, the parent, and here's the catch-all, relevant members of the CSE as determined by the parent and the school district. Here's a question for discussion. How many of you have your principals attend MDRs? Looks like it's a mix. How many of you like it when principals attend MDRs? Well, so I think there's pros and cons there, right? This is a question I've been getting frequently as well, because I think principals, because of the implementation of the workplace violence, they're getting a lot of pressure from the teachers to be really hard on suspension, right? And to be hard on discipline. That I think can be a negative influence sometimes at manifestation meetings, because the purpose of that meeting really is non-disciplinary. It's really to look at, the nexus between the student's behavior and disability. It's not punitive in nature. I think sometimes when you have building level leadership at that meeting, it can send those meetings in the wrong direction. On the other hand, the principal is the person who likely investigated the underlying misconduct. They're likely familiar with all of those facts that we were going over before. We know what were the precipitating factors, what the commonalities in what prompted this behavior, etc. So from that standpoint, it can be beneficial to have them there too. My take is I don't have a problem with principals attending MDRs. However, they need to understand what the purpose of the MDR is. They need to be trained on the factors that are considered and what their role is, which is to simply provide information about the underlying misconduct so that the MDR team has that information. Question in the back? So the question is there a requirement or a mandate of a gen ed teacher at an MTR? And the answer is no. So for contrary to CSE, where that is a mandated district participant, that is not the case for MTR. So there may well be a need to have it there depending on the context of the misconduct, where that would make sense, but it's not a mandate. No. I think there's a question in the back here. Oh, that's a great question. So the question is, what happens if you notice both? I think I'm understanding. Notice both an MDR to be immediately adjourned and then followed up by a program review meeting, which is a pattern actually that I recommend often, because if there is a situation where a nexus is found and the building feels like they have no other options, right? You're going to want to review that child's program placement, CSE, as the way of addressing that. The behaviors that have occurred. So the CSE portion of that meeting is technically subject to a 5-day notice requirement. That notice requirement can be waived by parents. I would say typically in the case law, the failure to provide the 5-day notice is deemed to be a procedural oversight rather than a substantive oversight typically. So that's one of those things we would say, consult with our team, right? Because there may be situations where we would say the risk of moving forward with that, notwithstanding 5 days is worthwhile. But other situations where
Yeah, sorry, I very obviously wanted to say something right now. Okay. So yeah, I agree with Kate, but for those of you who have been cited for disproportionality by the state recently, the state is telling you that you don't need to give 5 days notice for that CSE meeting because they're relying on this provision of the regs 200.5C1, which says we don't have to give 5 days notice for anything related to Part 201. Now, we've always interpreted that to mean the manifest,
not the
right? Not the actual CSE, but the state is saying that we can use that for the CSE as well. And the reason I think they're telling us that is because the state is telling us that even in a situation where we don't find a connection, that we have to have a CSE meeting to determine how the student will continue to make meaningful progress on their IEP goals, essentially how they'll receive their special education supports and services before we can impose that suspension. So if we don't have that CSE meeting right away, the kid comes back, even if they're on long-term suspension. According to the state, I'm not saying I agree with this, and I'm not saying this is explicit in the regulations either. And so the state, for those of you that are being cited for disproportionality, is advising you to automatically schedule a CSE meeting back to back with the manifest every time.
Thanks, Anne.
Oh, sorry.
God, it's so annoying.
Morning too. Just a couple of thoughts. Occasionally a nexus will be found. That means the student has to go back to school. And we use the program review to place the student on home instruction. So procedurally, that's correct. You follow the right process, you have the right meeting. But the parents' attorneys pick up on the fact that we're circumventing the nexus finding. And so I've had a lot of claims where they say that's exactly what we're doing. And then, so it's tempting, but so you will follow the right procedure, but you still have to defend the appropriateness of a one-on-one high school program. So it's like, it's a, yeah, yes. A couple of questions too that have been, and Kate, this means that everybody's listening closely. So questions is one is, and maybe why don't I take, why don't you take this and I can speak. Yeah, so.
You might want to get closer to the thing.
Come over here, Jeff, so that the online folks can hear over here too.
Well, actually, I'll read them for you and then, sorry. So the first question is, just for clarification, prior written notice. So there was a question, it says here.
Sorry.
Yeah, prior written notice is or is not required. So I'll just do a quick. You need a prior written notice for the manifestation meeting and the CSE meeting. The manifestation meeting is not subject to 5-day advance notice. The program review is. Okay, but the regs say, so, okay, wait, what's that? Okay.
The state says that provision means that you don't need to have 5
If basically, if you have the
for the CSE, okay.
if CEQA cited you for disproportionality and is in your business auditing your MDR compliance, I think what Ann's saying is you can play fast and loose with this rule and the state is not going to cite you for it, right? Even though we all agree that technically the regulations require a separate 5-day notice for the CSE.
That here, Kate, that was so good. I'm gonna do oh yeah.
Thanks, Jeff. So other point before we move on from the notice requirement that I also want to make crystal clear. If you are scheduling a program review to follow the MDR, keep in mind that that program review is going to have all the mandated participant requirements. So even if you use a more streamlined team for your MDR review, you are going to need to have a full team for the CSE. So what most districts do, I think, to ensure compliance with this is simply have a team present for the MDR as well, close out the MDR, and then, and then convert it into a program review. In terms of what is reviewed during an MDR, I think it's,
Well,
yes.
I don't want to.
I love being thrown off task. Throw.
Would that be the same for a 504? Is that the same recommendation for a 504 or not?
So the 504 mandates are much more, I would say, flexible, generally speaking, because the regulations don't dictate a specific process for those MDRs in the same manner that is dictated for under 201 for IEP kids. Our general advice, though, has been that because the federal government has said that all of the procedural safeguards that apply for IDEA students are also applicable to 504 students, that you mirror your discipline procedures for both. The only place where I think there's a lot of ambiguity there is the availability of an IAES, an interim alternative educational setting under 504, because that's not a remedy that exists under 504. But in terms of your notice, your participants, all of that, I would follow the IDEA process, with the exception that because of that, and I think everyone knows this, so I'm probably stating the obvious, but for 504 committee, all the regulations say is that it has to be a committee of knowledgeable persons. That's it, right? People's knowledgeable about the student and knowledgeable about the student's evaluation. That's it. So that provides tremendous flexibility in the composition of that team that does not exist for IEP kiddos, right? So if you are doing an MDR for a manifest or for a 504 eligible student, your program review need not have a full CSE. It could be a more streamlined 504. That's a great question. Any other questions about the program review versus MDR? So next, we're going to talk about the coordination of the superintendent's hearing with the MDR and other due process procedures. So essentially, these two procedures, the suspension process under 3214 of the education law and the 201 procedures for MDRs, our lawmakers have tried to ensure that those overlap well. They don't always overlap perfectly. So we're going to talk about some of the variations. Jeff's going to take over here.
Thank you. Okay, so thank you. So now, on some level, this gets easier, and on some level, it gets more complicated. So now we're out of the world of pattern. We're in the world of superintendent's hearings. Okay, so and this is the most common setting through which we conduct manifestation meetings. So the regulations, well, it's what's common. You get a superintendent, you get an invitation. Superintendent's hearings at 9:30, manifestation meetings at 10, right? You get this all the time. Why is that? Because the regs actually lay out the order for this process. It's in the regs, it's in section 201, and it has a nice little, if you ever look in the regs, 201, in the back, it says like coordination with superintendent's hearings. And it's an order. You like Shakespeare? Everyone loves Shakespeare. Remember those plays in high school? I think I've heard Shakespeare once. There's 5-act play, right? Act 1, Act 2, Act 3. This is it. And we've got 5 acts. And it's laid out in this process. Act 1, superintendent's hearing. Okay. And we've all participated in these before. So the process, does it continue or not? Because at each step, the process could end. Step 1, superintendent's hearing. Penalty is guilt or innocence phase. You're breaking it down. Is the student guilty or the student innocent? If the student's innocent, we're done. Everything else is canceled. Go back to class. If the student's guilty, do we go straight to the next phase? Actually, we don't. There's another step. It's called a threshold determination. The superintendent, the hearing officer, has to decide, is this a violation which could lead to a suspension beyond 10 days. It's possible students found guilty and we're only going to go for 10. That's it. And if that's the case and there are no prior suspensions, so no pattern issues, we don't go over the threshold. We do not have to have a nexus meeting, manifestation. Most of the time, we say it could go over, but you have to make that distinction. And if you're ever trying to avoid a manifestation meeting, you could just say, I'm not going to go over 10. So keep that in mind. So that's step 1. So let's assume the student's found guilty, and we assume if it could go over 10, we end step 1, we go to step 2, which is the manifestation meeting. So you cancel, you stop the hearing, and everyone runs into the other room to do the manifestation meeting. Now, this is when the hearing officer says, hey, I've got 7 hearings in 12 districts today, so I'm leaving now. We're supposed to go, no, stay. Because sometimes you say, well, let's do the penalty phase now. You shouldn't do that. And does anyone know why you don't do the penalty phase with the guilt or innocence phase? Let's see, any lawyers here? Because it's prejudicial. That's one reason. Because if you're trying to, if you're a student and you're being accused of something wrong, you're not allowed to inject prior bad acts in there. The kid might say, I didn't do this, but the principal can say, well, he did 10 other things in the past, so he must have done this. That's why you cut it off. It's not allowed. Evidentiary, it's not allowed. So step 2 is the manifestation meeting. We've all been there. At the manifestation meeting, we determine if there's a nexus between the misconduct and the disability. Remember, focus on the misconduct, not the charge. It's the misconduct. If you fought procedurally, we're going to talk in a second about how to make this determination. But if there's no nexus found, then we go back to the penalty phase. Now, what if you find nexus? Well, you go back into the superintendent's hearing and go, we found nexus. We're done. We all go back with one exception. It's possible when you go back into the penalty phase, you go back to superintendent's hearing, you say, I know there's been a nexus, but there's 1 of 3 possible exceptions. The misconduct involved drugs, weapon, could involve drugs, weapon, or serious bodily injury. So the principal might come back out, or the representative would say, it was a nexus, but we think it's one of those three. Do you automatically go into an IAES at that point? No, you actually could litigate whether those three exceptions apply. Each of those exceptions is a high standard. Serious bodily injury is a definition of that. You might have to say, well, what was the injury? What were the records? Was it just a cut? Was it a broken nose? Was it a concussion? Was it a mild concussion? There's case law on this. Was it a weapon? Was it a knife over a certain number of inches? Was it a rock? Is a rock a weapon? Is scissors a weapon? Is a gun a weapon? Is a chair a weapon? This is the difference between a 1-year suspension and a 45-day IAES. Drugs, was it really drugs? So this step gets overlooked a lot. But if the hearing officer determines that one of these were met, then you can go for an IAES. Now, on that note, I'm going to take the question in a second, Kate. If the hearing officer determines, I know there's a nexus, but I know IAES condition was met, they have to figure out how long will the IAES be, and it's maximum 45 school days. And if the suspension would have been less, like 20 or 30, that's what the IAES would be. And the IAES, what is the IAES? Does the superintendent figure out what the IAES should be? No, it's the CSE. So the superintendent would kick it back to the CSE to be determined by the CSE. We just went through a lot. I got some questions. Okay, what was your question?
So something that comes up frequently, and I know what my answer is. I'm curious if you have the same one, Jeff, and Anne for that matter too. Often the question comes up. So let's say principal imposes 5-day suspension. Student has not been previously suspended in the school year, so we don't have a pattern of that. But there is a 5-day suspension that was lawfully imposed by the building principal. The district goes to an MDR prematurely, essentially. So they haven't got to 10 days, but they're doing it early. They're on day 2, let's say. They do the MDR. My take is if that MDR comes back that there is a nexus, kid goes back to school immediately, right? So I often have arguments from principals on this who say, but I get my 5-day suspension. I already imposed that. You should be able to complete it. My answer is no. Do you guys both agree with that?
Yeah, the party's over. No,
It's over.
That's why would you have it early? If you have to have it early, if you had 8 days before and you have it at that point. But okay, next question.
Yeah, so similar but different question in terms of if the principal imposes a 5-day suspension with a plan to go to superintendent's hearing, but the initial 5 days exceeds the 10-day mark, and you do a pattern determination, would you recommend holding the MDR prior to the superintendent's hearing? Instead of coupling it with
I think the key is going to be before the suspension.
Now, okay, so in the past, I would say you have to have it at day 10. But now we're hearing something different, right? So we're hearing something. I would say have it at day 3, but the regional associates are saying something different. Yeah. Okay.
So it's your question, Pam. Let me just make sure I understand your question. I'm just moving over here. I know it's weird, but I don't know if they can hear me if I'm down there. Okay. Is your question, you're waiting for a superintendent's hearing, while you're waiting, the student gets more than 10 days in the meantime, cumulative through the year? I think that's unclear. There's the commissioner's decision that came out 2 years ago on this issue where, because all of you get nervous as you should in the special ed world, we need to have the manifest, we can't have them out longer than that. But there was a commissioner's decision where a district did that and they held the manifest before phase 1 of the guilt phase of the hearing. And the commissioner found that was predetermination. And so because you don't know if the kid is guilty or not. And so I have relied on that when advocates and attorneys have said you have to have the manifest. This really comes up a lot when parents ask for an adjournment of the hearing and the student's out in the meantime. And then we kind of can get to more than 10 days in a row that way, or what you described, Pam. I've relied on that decision to say we can't I don't know if that was challenged through a due process hearing, if that would be a winning argument. Because the commissioner doesn't consider special ed side of things. She considers the gen ed 3214 side of it. So I think that's unclear. I don't know what your thoughts are on that.
Yeah, I mean, I would, I think it's a good practice to have it. You know, if I didn't know about the commission's decision, I would say have it, because I think it's a good practice to follow that 10 days, because if we sort of let things slide, we're gonna let a lot of things slide. But it's a tough issue. It's a tough. Is there another question? Because getting ready for we didn't even get to the good stuff yet. So, yeah, question.
Because I understand that the superintendent ultimately decide to impose the AES, but is that the CSE is gonna ultimately determine that looks like?
Exactly. The superintendent could impose an IAES, but only if there's drugs, only if there was a suspension, student found guilty, there was an nexus, and then one of those 3 exceptions apply. Superintendent can't just say, I feel like putting you in an IAES. So if under that scenario, you go through the process, the superintendent says everything was fit, we followed all the rules, terminations were made, it's drugs, weapon, whatever. 45 school days to be determined by the CSE. Superintendents they're not expected to know what an IAES is. It's an interim alternative educational setting. It's not punitive. Usually it's, if you're normally going to do tutoring, you give some counseling with it. You give some sort of something positive to address why the student got there. But to be determined by the CSE. Question. I'll be quick, but I really want to get to the juicy stuff. But questions?
For 3 days, and a parent requests the manifestation.
Yeah. So, well, can a parent? I think it's could, should, or must. A manifestation is an obligation. It's not necessarily a right. I mean, it's different ways. Like, can you waive a manifestation? Nobody knows. Like, is it a right or an obligation? And it's different. Nobody knows for sure. But the question is, if you're at day 3, does the district have to have a nexus meeting? No. Do parents ask for it? Yeah. Why? There are some schools that say, oh, we're approaching 10. We're at 8. Let's have a manifestation meeting. Why? Okay, the first rule of special ed is if you don't have to do something, don't do it. Okay. Okay. Now, do you want to have a program review meeting? Sure. But remember, as Kate said, there's no reset. There's no benefits doing it at day 8. So, okay, all right. So, Leslie, yes.
Superintendent hearing, and then they determine whether it's one of those 3.
Yes.
So it's the hearing officer.
Yeah. Hearing officer has to make that rule. So you walk in and go, oh, it was a nexus, but we think these conditions are satisfied. Well, they'll have a good idea that it's coming, but they still have to go to the hearing officer. The parent can say, no, that's not true. It's just a bruise. And these are serious thresholds. There are cases where a light concussion was not enough. So it's a tough one. Okay, so yes. Yeah.
SCD came out in the fall, interpreting serious bodily injury as just extreme pain. So we have actually had staff members say, I was in extreme pain. Boom, IAES. Have you seen anything from SCD clarifying?
No, they are saying it, but not writing.
I haven't seen that in writing, and they're just, and what SCD's view is not enforceable if it's a hearing or a state review officer decision or a court. So, yeah. No, it's crazy, but it's not. Okay, step 3, penalty phase. In a normal situation, if there's no nexus, you go back to the penalty phase, you can punish as long as you want. There is no 45-day max. There's a myth out there that you can only suspend kids after the next 45 days. It's not the case, but you can see why someone would have that misunderstanding. You could suspend for a year if a gen ed student will get a year. Okay, then the CSE meeting we talked about before. Okay, so let's talk about, though, the purpose of this presentation, is what are you doing at these manifestation meetings? How are you getting this right? Are you making the right decision? Is it a nexus or isn't it a nexus? So when you're at a manifestation meeting, you're asking 3 questions to figure this out. 1, was the misconduct caused by the student's disability? Was there a direct and substantial relationship between the misconduct and the student's disability? Was the student's conduct the direct result of the school district's failure to properly implement the student's IEP? 3 questions. 1 yes gets you a nexus. You don't need all 3, you only need 1. There used to be a 4th question. It was the IEP appropriate? If the answer was no, it was an automatic nexus, but they got rid of that in 2004. But just so you know, from a practical standpoint, the caused by, it's very rarely going to be caused by. The only time you're going to see a misconduct caused by, maybe if a student has Tourette's, but very rarely you're going to see caused by. I'm just the failure to implement, direct result. So if you didn't get resource room the day before, you're not going to get a direct result between the misconduct. Remember, an IEP, a BIP is an extension of an IEP. So if you didn't implement the BIP and it led to misconduct, you got a direct result. If you missed counseling 3 days ago, you're so distraught, you're not missed counseling, you did something, probably not. But direct result, it's a hard standard. It's possible, but it's direct result. 90% of the cases deal with direct and substantial relationship. That's the universe in which you're living.
Yeah.
Yes.
Can I just share an anecdote?
Yes. Yes.
So I agree with you that the category that most typically comes up, I think, is the direct and substantial. But don't overlook the IEP compliance criteria as well, because that actually did come up in a situation for me recently, where essentially the student got into an altercation in the cafeteria with a security monitor. The student's BIP and IEP both reflected that when the student became escalated, the techniques that were supposed to be used were avoidance, walk away, give the student space, allow the student to de-escalate quietly. The security monitor did not know about the student's IEP, did not know about the BIP, and when the student got in his space and engaged in a verbal altercation, the security monitor started swearing at him, yelling at him back,
right,
basically engaging with him in polar opposite of the methods and techniques recommended by the IEP. So in that situation, the district said, well, but we read the IEP and it's not a manifestation of his disability because we don't believe there's a nexus. But there has to be by definition, because the main witness acknowledged that he wasn't even familiar with the techniques that were supposed to be used. So that could be an example where, even though there isn't a nexus in the sense that this is a manifestation of the student's disability, it still qualifies for an MDR because the cause of IEP.
Right. Yeah, I think, yeah, exactly. So that's, yeah, so it is a direct result between the failure to implement the BIP and the resultant misconduct, that's an nexus. So let's go to the biggest, the most likely scenario is the direct and substantial relationship. What does this mean? What does direct and substantial relationship mean? This is what you're sitting, this is what, when you're sitting at these meetings, this is what you're going to be discussing. So we don't know exactly what this means. That's great. So we have to put on our detective hats to figure this out. So we know that in 2004, Congress, when they reauthorized the IDA, they said to get a direct and substantial relationship, the connection cannot be attenuated. Does anyone know what attenuated means? I think it means like loosely connected. So, if it's an attenuated association, like you say, oh boy, this child has low self-esteem, that's why he did something. That's not enough. It's got to be direct and substantial. That's one little piece of the puzzle. So, through case law, a couple of legal principles have emerged. First, again, unless there's a clear and direct link, a nexus should not be found. The student's mental state at the time of the misconduct is very important. If the student understood that his conduct was not allowed, then in most instances, a nexus should not be found. Not all, but that's a sign that it might not be a nexus. Now, again, if the student has a conduct disorder, and you need a pretty severe disability to know you're doing something that's not allowed and still do it. It's not impulsive. You're actually thinking it through. Usually, most of the time, you're not going to get a nexus if they know it. Second, impulsive acts are more likely to support a nexus determination, while planned acts generally do not. So you really need to look at, is it just two kids bumping into each other and one responding without thinking? Or is it a planned over hours or days? We had a case where someone drafted a hit list over days. Suddenly, that's not impulsive. And so you could have somebody impulsively grab the weapon, brings it to school, but they put it in their locker. That might have been impulsive when they grabbed it at home. Is it still impulsive 4 hours later? Probably not. So it depends on what's happening. You really got to break it down. Next, this is the most important factor. The most important factor is the MDR team has to ask, how has a student historically been affected by his disability? No generalizations. We don't say, oh, kids with autism, here's how they respond. It's how has this student been affected by that disability? And again, the greatest example, it's so easy. I wish they could all be this easy. Student with ADHD. One kid with ADHD, you look up and down the IEP, it says behavior, 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 behavior plan, counseling. There's all sorts of inappropriate behaviors. Next kid with ADHD, it says learning, 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 extra time, consultant teacher, nothing, no mention of behavior. When the learning student punches his friend in the nose and the mother says, hey, it was ADHD, say, wait a minute, that's not how it affects you. So you really got to break it down. Behavior rating scales, if you can find those in the record, those might really be helpful. So that you really break it down, no generalizations. A couple of relevant case decisions. It's rare that these go to court, but I got a couple of relevant case decisions. Again, here it is, Pennsylvania State Agency using that attenuation word. Again, not a mere, it should say mere correlation or attenuation. That's not enough. You need a direct result. Here, in Michigan State Educational Agency noted an important factor is dealing with impulsivity and examination of whether the student was able to fully comprehend the potential consequences of his or her actions. If they understood it was wrong, it's probably not impulsive. Oops. Okay. What just happened? Okay. Here in Connecticut, a student was manufacturing a bomb. You got to give kids credit these days for engineering and smart. We got a lot of smart kids here. But he manufactured a bomb, but it was over a period of time. So this couldn't have been impulsive. It was planned out. Another one was the student's actions. Here, this student had a history of disruptive behaviors characteristic of a disability. it's almost like the kids with bad records get rewarded at manifestation meetings. And I don't think that's a consequence of it. But if you have a history of misbehaviors and a disability that's prone to cause these behaviors, once you got the dots, it's not that hard to connect them. You'd rather not have dots to connect. You'd rather have a diagnosis without a history of that type of behavior. Once the history is there, it's hard to not connect them. A few more is, again, a plan to distribute. You understood, again, look at, and again, sometimes if you're really sharp, you got to be planning this out in the charges to explain, and in the hearing, you need to establish that things took place over time. That's relevant. And again, a couple other points. Failure to implement is a failure to implement is not automatically resulting in an exit determination, but it certainly could be if it's a direct result. And you know it when you see it. The BIP is the most common case. I always like to use the example. The BIP says, don't talk to Johnny in front of his peers, and the substitute teacher doesn't know it, and he yells at Johnny in front of his peers. Johnny flips out. That's an nexus.
Got another question for you?
Yes, yes.
What about ODD?
Yeah,
That one always
yeah.
throws me for a loop.
Yeah.
Because parents can get this oppositional
Yeah.
defiance
yeah. No.
diagnosis.
Oh, oppositional. Yeah, it's a lot. It's going to be tough if you have oppositional defiance disorder and the child acted in an oppositional way. Might be it's tough. And so what we say is for parents to prevail in these, they shouldn't lawyer up, they should doctor up, because it's the diagnosis that carries the day. And also, if a parent walks into a manifestation meeting with something, we can't just say this is new. We're going to ignore it. But again, they come in with a new diagnosis and they don't have a history of that behavior. We're going to say you can have your ODD diagnosis, but you don't have. There's no record of it impacting you this way. You've never hit anyone before. You've never acted like this before. On the other hand, if they have a history of acting that way before and they have the diagnosis, we might have a problem. Okay. So then, and then what if the MDR team answers one of the three questions in the affirmative? The suspension is over unless you have a BIP, unless you have an IAES. And two exceptions, and we talked about before. Technically speaking, they could. Technically speaking, even if a nexus is found, the parties could decide to alternative placement. In the meantime, it rarely happens, but it's possible. It can.
So question,
Yeah,
is that communicated through the manifestation team at CSE, or is that communicated to the superintendent in his?
What's that?
If the district and family agree upon.
That would be more of a CSE issue. Yeah. I mean, you could do it anytime, and they use a strange language. Says you could agree to another program by changing the BIP, so that it's weird. So does that mean if you don't have a BIP, you can't change it? It's weird.
That often happens after the CSE or the MDR has determined that there is a.
Yeah.
The building and family work together to keep the kid out.
Yeah, because they'll say, look, Johnny, it's a nexus. He's going to go back to class tomorrow, but say, do you really want him to go back, get in trouble again? It's not his fault, but maybe it's in his best interest to take a couple of weeks for home instruction. We can't unilaterally impose that outside the CSE, but if they agree to it, then there's your cover. And then we're gonna and so Kate, are you on next? Yeah. And then we're gonna have a few more slides because then we're gonna take a break in a few minutes to stay on schedule. But here's Kate, and then one more. We got one question. Yeah, or maybe 5. Yeah, if we can do 5. Yeah, great. Is there a question?
I'll ask one. You talk a little bit just about MDR team, quote unquote, who makes the decision? Because I'm often not asking representatives their answers to these questions. I'm guiding through as the person that's.
So is the question who decides who is part of the MDR team, or is it?
Those 3 questions.
Mm-hmm.
If I have a feeling there's going to not be consensus within those answers, I guide the questions
So I think the only guidepost we have for that in the case law would be, we have a couple of opinion memos that basically say that in the CSE context, the CSE chairperson doesn't need to be impartial, so to speak, that if at the end of the day, there's a lack of consensus around the table, the CSE chairperson, and in the MDR context, the MDR chairperson is ultimately the district representative. The district is the one that has the obligation to provide faith. So ultimately, as the chairperson, if there's a lack of consensus, you get to call the shots on it. You get to make the decision. And that is often the case too if there's disagreement between the parent and the district participants at CSE. Again, the parent is a mandated member, but they do not have a veto over the CSE process. And if you have a situation where, you know, several staff members maybe even disagree, maybe the principal says no nexus, special ed teacher says no, I think there is. Ultimately, the decision falls on you as the chairperson to be the one that makes that decision to ensure compliance with the law. I don't know if my colleagues have any different take on that. Or...
Whatever the chair says goes.
Whatever the chair says goes.
Standing on that. Like if everybody there is all standing connection, it would be risky for you as the chair to be like, no.
Oh, well, because no, that's a great point. So what Ann just said was, as a chairperson, use common sense. Right? You never want to be in a situation where you are calling the shots and that's contrary to the consensus of the rest of the team. Why? Because if there's an impartial hearing, guess who your witnesses are going to be? Everyone at that CSE team, right?
Yeah.
Right? So those people need to, you need to be able to back up with evidence, data, whatever decision you're making. Probably goes without saying. Students presumed to have a disability for discipline purposes. Jeff's going to stick a hook out, pull me off the stage in like 5 minutes. So I'm going to try to zoom through this really efficiently. This is, I think, one of those, the practical, yeah, I'm not going to belabor the rules because I think everyone's familiar with them, but I think the practical situation that comes up here that's very complicated is, what do you do with the MDR process when you have a student who is suspected of having a disability but has not yet gone through the CSE referral process? That's a difficult situation because by law, you are treating the student as though they are disabled. You're performing an MDR, but you may be very early in the CSE process. Maybe you started the evaluation process, but you haven't completed. What are some things that you can do? And I'm eager to hear my colleagues' views on this too. Some of the things I recommend in that situation, I will often say to districts, expedite the behavior portion of the evaluation. You know, Jeff had referenced behavior rating scales, right? Maybe expedite getting those scales completed by the classroom teacher who serves the student on a daily basis, the parent, and the student themselves, because then at least you're going to have some data that doesn't need to await the completion of a formal eval that can then help you make that decision. Another thing that can be helpful, look at what the basis for the referral was, right? Why was the student referred to CSE? Were they referred to CSE because they are, you know, they've gone through RTI and they're still not making adequate academic progress? That's not a great case for a nexus, right? Because it's not behaviorally based. Versus if you have a kiddo that's been referred to CSE because they're engaging in explosive, problematic behaviors, and then while that evaluation is pending, the kid engages in explosive behaviors, there's more likely to be a nexus there. Something that I think is often overlooked as well in your higher liability cases where you suspect the parent could be difficult, you might want to keep this in mind. There's nothing by law that says that a student has to be suspended while the superintendent's hearing is ongoing. You can always send the kid back to school, conduct the evaluation, wait for the evaluation to be conducted and have that data that will make the decision. Districts don't like doing that because there's the concern, like Jeff said, about specific and general deterrence, wanting to make sure that the penalty immediately follows the crime, so to speak, but that's the mandate. You can return the child to school evaluation. Looks like there were a couple questions in the back. Sir?
Yeah, parent never made a CSP or 504 hearing officer found out
Yeah, so that's a great question. The question was essentially they go to a superintendent's hearing, and during the hearing, for the first time, the hearing officer learns and the administration learns that the student has an undefined medical. Is that your question? So if we look at the criteria for what is considered to be a student presumed to have a disability, that on its face does not satisfy the test. The test requires that the parent has either expressed in writing to certain individuals that the student has a disability or may have a disability, that the student was actually formally referred to CSE, or that a teacher or staff member in the district has expressed specific concern about that behavior being related to a disability. If that was not communicated formally before the misconduct occurred, this is not a student presumed to have a disability. That said, I would say this is a bit of a trap for the unwary. And it's a place where you can do some damage control, I think, by training your hearing officers to handle this pattern when it comes up. When this pattern comes up, parent says at the superintendent's hearing, well, here's my doctor's note. Child has OTD, child has ADHD, child may have all these concerns, right? What should you do with that? Just because the student is not presumed to have ability for discipline purposes doesn't mean that you don't have obligations. That to me would clearly trigger a child plan. The provision of, at the very least under 504 and potentially under IDEA, there's educational impact as well. So what I typically advise hearing officers to do in that situation is to go through this checklist on the record, go through the checklist with the parents. Did you express a concern in writing? Who did you express that concern to? Has the child actually been referred to CSE? Have the hearing officer establish a record of going through these prompts? So then there's a record of why the student doesn't qualify for an MDR. But then I always like to tell the hearing officers also, on the record state, okay, I'm concerned, however, about the concerns you raised, parent, so I'm going to recommend that the superintendent refer this to CSE for further consideration. So you don't want to miss that child line trigger as well. Yes.
Through looking at the child side, or reporting to students of referred to even if they're the outside thing. I thought I heard you say earlier, we should look at even prior to that sort of formal child side to make the categories for referral to CSE, that we should be backtracking and counting that the days that are reviewed before that. So I'm just kind of thinking of the impact in a larger district as we're working for our kids who are actually through the MDR process to use medication, how we would even manage that, or if that's a really high threshold, if that's a part that we're not required to get to, because that's impactful. Think about kids that aren't even moving through a referral process, but they haven't presented for multiple days to go to that.
I think the concern would be, and what Jeff was referring to earlier, was a situation where student was ultimately classified. In that situation, we would say, even if some of the misconduct predated the classification, you would still include those days as part of your pattern analysis. I do not believe in the absence of these are essentially child fine triggers, right, under the regulations. In the absence of those three triggers, I don't think you need to be digging for additional MDRs to do. You all have enough MDRs to do. I like Jeff's statement. If it's not mandated in special ed, don't do it. So on that note, Jeff's telling me I'm out of time.
Let's go through the slide. We got 2 more slides, and then we're gonna take a break in a couple of minutes. I think we got a couple of slides.
Finish the slide.
For some reason, the clicker is not working.
Oh, weird.
Neither the clicker nor the.
Uh-oh.
Uh-oh. I feel a little frozen.
Oh, here we go.
Aha.
Okay, so a couple more slides here before we break. Students presumed to have a disability is entitled to all the procedural safeguards in Part 201. So back to the prior question that was asked, that's why we don't want to be doing MDRs where we do not fall into one of these buckets of a presumption of disability, because you're radically expanding your workload there. There are exceptions. A student may not be presumed to have a disability under these 3 circumstances, and these make very good sense if you think about it, okay? So if the parent has previously refused evaluation the student loses their status as a student presumed to have a disability, even if that referral was made, even if a staff member complained, etc. If the parent does not consent to evaluation, the student is treated as a gen ed student for MDR purposes. Same as if the student was classified through CSE, but then parent declined consent to initiate services. Similarly, we cannot be expected to treat a student as a student with a disability that we're not also allowed to serve special ed. It's just kind of common sense. And then finally, this one probably is that thing, but if CSE goes through the referral process and ultimately determines that the student is ineligible, they would likewise lose their protections. So this can be used strategically in situations where parents are insisting on keeping their children in settings that are inappropriate. This is often the best thing that you can do to educate them about the consequences of that. Yes, you have the ability as a parent to decline special ed and therefore turn down this BOCES program, this therapeutic program we're recommending. But if your student comes back as a gen ed student, they lose all of their Part 201 disciplinary protections. It's, in most things in special ed, I say the parents can have their cake and eat it too. Frankly, this is one of the areas where that's not the case. You cannot have your cake and eat it too. If you block the district from serving your child, you can't then insist on the child receiving disciplinary protections. Contrary to the rules for pattern determinations, which are silent as to who actually performs that decision, there are certain individuals specifically listed who are supposed to make the decision about whether a student is presumed to have a disability for discipline purposes. And it is basically the person who is imposing the suspension. Under New York state law, the superintendent of schools, a building principal, or the Board of Education, that's something that people often forget, have the authority to impose short-term suspensions on students. In practice in most districts, it's the principal that does the short-term suspensions. And then if the suspension exceeds 5 days, that's when it would go to the superintendent to impose longer-term suspension. So depending on who is the suspending agent, that person is also required to then make that decision about whether the student qualifies as a student presumed to have a disability, which I think that presumes some diligence on the part of that principal to, at the very least, confirm with special ed. Has a referral been made? Is this kid on your radar? Is this kid an RTI? Is this a kid for whom we had any notice of concern? Again, if that due diligence has been done and the kid is coming up clean, you go to a hearing. If the parent raises those disability concerns, basically new at the hearing, we would handle it the way that I advised earlier. I think this is natural breaking point.
These two, this.
Okay, this one I won't belabor because we've already spoken about it. Section 504 bullet point is that even though the regulations are silent as to an MDR procedure for Section 504 students, the Federal Department of Education takes the position that as a matter of anti-discrimination, 504 students are entitled to all the procedural safeguards of the MDR process. As I said before, there's some confusion regarding whether the IAEF is available. Yes, United Due Process Procedures, not that. Those issues have not been litigated. But generally speaking, students with 504 plans are also entitled to MDRs.
No,
Yeah.
no.
Yeah. Yeah, 5-minute break. Thanks. Okay.
Oh, that was weird that they just got her.
Okay.
Okay. This topic. Right. Probably not. Well, you're easy, boy, child, living. Yeah, and then you go march and drop fire. But then, what are you gonna do? What can you do? You want to mention that? You will. Yeah, yeah. And the bottom part, yeah. There's no bottom line. If you're very simple, there's bottom line, but no bottom line. Yeah. It's like that. Yeah, well, it's, there was that one judge. That's something. That, like, yeah, I was insane. Yeah, right, right. Like, yeah, he criticized me for the whole job. I don't worry about it. I think it's all a couple issues. Okay. I'll be right back.
So I think a parent, like, we're going to something. We don't have. That's a hundred. My situation. Letter off here. Sign. And then. Like, the parent has not been concerned with that. We reached. That, right now, so that. Yeah. Yeah. Okay. Yeah. It's the. So we can start. Yeah, but we don't have the camera ready. Yeah, so, I don't know. We're talking. Yeah.
But started earlier. But still. Yeah. Yeah.
Probably could meet either classification. They meet one, they might, well, no, let me put that back. If a student meets ED classification, they probably would meet OHI class. If we're, not always vice versa, but sometimes. But we're going to talk about that in different considerations to break it down. We're definitely seeing students with more significant needs, behavioral and social emotional needs. And so we're seeing these classifications come up more. I find that CSEs frequently feel like they need to identify the classification that best meets a student's needs. And the law doesn't really require that. The law requires that we find a classification that works, that the student legally meets. And it could be more than one. And so if you have a situation where a student meets more than one classification criteria, I don't think that's the hill to die on. So if parents feel very uncomfortable with ED and emotional disability classification, but the student meets an OHI classification, it's okay. You can call them OHI. That's okay. I'm giving permission for that. Because all the classification does is open the door. Classification doesn't drive the programs and the services and the goals on the IEP. It's the students presenting needs that do that. So again, not the hill to die on. We're not legally obligated to find the very best one. In an ideal situation, we would. But if a student meets more than one, you have options. Okay, for all of the 13 special education classifications, we need 2 prongs for the student to be eligible for an IEP. The first one is that the student has a disability, and we figure out the student has a disability based on those 13 special education classifications, the criteria within those classifications. But then the second prong is, by reason of that disability, they need special education or related services. So you need both. You have plenty of kids in your schools who have disabilities, but that don't need CSE classification because they don't need special education or related services. Now, the only entity that can decide that is the CSE. So I find at times, sometimes districts want to push back on a parent referral, or districts don't refer because they say, well, we know they have a disability, but we don't think they need special ed. If there's a question around that, we should be referring to CSE, doing that evaluation, and letting the CSE decide if the student meets special education criteria. There's a few reasons for that. Number one, we have our child find obligation to identify any students with qualifying disabilities. We can only do that through CSE. Number two, parents are an inherent part of that process. And if we're deciding outside of CSE that they're probably not going to qualify anyways, we're removing parents from that process and removing all those rights that they get as part of that process. And number three, it's predetermination. You're making a CSE decision outside of CSE. So when in doubt, refer, do the evaluation, and then let the CSE decide if these 2 prongs are met and if the student is eligible for classification. Something else that's very important is a formal diagnosis is not required for CSE classification. You do not need a formal diagnosis for any of the 13 special education classifications. And this is something that I see CSEs get confused about a lot, especially for ED. A lot of times CSEs say that they think that a classification is needed, some kind of mental health diagnosis. I see it for OHI, I see it for autism, but none of those classifications require a formal diagnosis. What's required is that the student meets the criteria within that classification. And if you read that criteria, there's nothing about diagnosis, including for autism. The autism classification criteria is different from the DSM diagnostic criteria. Similar but different. If your CSE would prefer to have a diagnosis, which is okay, when I was a CSE chairperson, when we were looking at ED, I felt more comfortable knowing if there was an underlying diagnosis. You have a couple of options as a CSE. One is you can have your school psychologist determine if there's a diagnosis. Under the education law for the practice of psychology, school psychologists are able to diagnose. In most circumstances, they are not doing that. And that's okay. You don't have to have them do that. And school psychologists should not make that decision on their own. It should be a district decision. You have to make sure that they have the personal competency for that and they have the necessary tools to do that. And it should be, again, a district decision. But some districts are moving in the direction of training their school psychologists to engage in anxiety and ADHD diagnoses because there's so many kids with those needs. And that's permissible under the education law. The second way you could do it is by contracting with a third party, maybe a psychiatrist or a medical doctor, to be part of that CSE evaluation to determine if there's an underlying diagnosis. That's the way that my district did it. When I was a school psychologist, we had a psychiatrist that we contracted with. What you can't do is tell parents they need to go out and get a diagnosis. We can't say to the parent, we can't find your kid eligible because you haven't provided us a diagnosis. Maybe if you provide us one, we can find your child eligible. That's not permissible under the law. And that's for two reasons. Number one, that child find obligation that we have, it's our obligation to identify the disability related needs. And number two, we have to provide a free, appropriate public education, and placing that responsibility on parents to go out and get a diagnosis is not free for them. So we cannot require parents to give us a diagnosis. If parents share a diagnosis with us on their own, great, we should consider that. We're required to consider anything they give us. If we're happy with that, we can move forward, but we can't require it. But again, backing up again, you don't need a diagnosis to get there. So you can use the evaluation that you have and the information that you gather through the CSE process to get to any of those 13 special education classification. The same premise applies to 504. You do not need a diagnosis for 504 eligibility. For 504 eligibility, you just need a physical or mental impairment, not diagnosis, that substantially limits a major life activity. And the way you figure that out under section 504 is through an evaluation. So we are supposed to be doing evaluations under section 504 to determine eligibility. All right, let's talk about the emotional disability classification. For an emotional disability, a student has to have one of these 5 things that we're going to be talking about, and it has to be over a long period of time to a marked degree, and it has to adversely affect a student's educational performance. We're going to talk about all of that. One of the 5 criteria is an inability to learn that cannot be explained by intellectual, sensory, or other health factors. So if a student is struggling to learn, but it's only due to having an intellectual disability, then we would not classify that student as ED because it is explained by the intellectual disability. Now, it's possible for a student to have an intellectual disability and meet ED criteria. That's what the CSE has to determine. And in that situation, the CSE could classify with either, probably also multiple disabilities in that situation, if they meet classification criteria for both intellectual disability and ED. Number 2, an inability to build or maintain satisfactory interpersonal relationships with peers and teachers. So we're looking, obviously, at the relationships with others. We're looking at, does the student disregard the feelings of others? Do they have social anxiety? Do they not understand how others are feeling? Are they taking advantage of others? Number 3, inappropriate types of behavior and feelings under normal circumstances. So this can include difficulties with regulating behavior, difficulty controlling anger, overreacting to certain situations. Number 4, a generally pervasive mood of unhappiness or depression. That's self-explanatory. Is the student depressed? And number 5, a tendency to develop physical symptoms or fears associated with personal or school problems. This could be the somatization scale on the VASC. This could also be students who have school avoidance, school anxiety, school phobia, school refusal, whatever we're calling it. Students who are unable to come to school because of an underlying anxiety or other type of disorder. Let's talk about that a little bit, because I feel like I have to talk about that every time. For kids who are not coming to school due to anxiety, because it's such a major problem right now. What I see happen a lot for students who are unable to come to school for anxiety is schools say, well, their achievement is fine. They're achieving in the average range, so there's no adverse educational impact. But when we're talking about adverse educational impact, we're talking about a lot more than just their achievement. We're talking about their ability to come to school and be part of the school community. And not being able to come to school over a long period of time because of a disability, that could be the educational impact, that inability to come to school. All right, for ED, the term includes schizophrenia. I don't know why that's in there. I started my career out as a therapist in residential. I have never interacted with somebody under the age of 18 with schizophrenia. Does not happen that much, but it's in there in the regs. So it includes schizophrenia. It does not apply to students who are socially maladjusted unless they also have an emotional disability. We're going to talk about that a lot. So a lot of times CSEs think that if social maladjustment, which is like a conduct disorder, engaging in criminal rule breaking type behavior, if a student has social maladjustment, then that means that they cannot be classified. That's not true. We have to figure out if all of their needs can be attributed just to the social maladjustment, or do they also have an underlying disability in addition to that? Because they could be socially maladjusted, but also meet ED criteria, and they would be eligible for classification in that situation. What does over a long period of time mean? We don't really know. The regs don't tell us, but we do know that it probably should at least be several months. Under Section 504, anything less than 6 months in duration is considered a temporary impairment. And again, we're talking about CSE here, but it gives you an idea of how long we typically want to see something. It's going to really depend on how significant it is as well for how quickly you have to move. But definitely waiting years is too long. And I know that I sometimes as a school psychologist waited too long to refer students with behavioral or social needs because we had so many building level interventions that we put into place. And we would say, well, what's the difference if we classify? We'd be doing the same thing. That's a problem because that means that you're giving special education level support outside of special. To a marked degree, again, that's not defined in the regulations, but we know that it needs to be more significant than what you're seeing for a typical general education student. And standardized assessments are very helpful for this because they give us percentiles and they tell us how a student is performing compared to same age peers. So we want to collect that standardized assessment evaluation around social emotional needs and behavioral needs, in addition to lots of other information, and making that determination if it's to a marked degree. And then adversely affects a student's performance. So I talked about this a little bit. Those days of just looking at achievement are over. Achievement and grades are important. They're an important part of it, but we also have to look at the student's ability to attend school, to participate in school, how they're doing when they're in school, what type of support they need from us. Those are all relevant factors in determining if there's an adverse impact on their educational performance. We're going to break down social maladjustment. Again, that's also not defined in the regulation. When we look at research for what social maladjustment is, Stephen Brock does a lot of research around this. There's a lot of materials out there from him. And some clinical criteria for social maladjustment includes things like a lack of motivation or interest in school, self-centered, impulsive, and irresponsible behavior, low frustration tolerance, rejection of authority, absence of concern for the feelings of others, projection of blame for socially prescribed behavior, violation of rights of others, habitual lying, inability to delay gratification, stealing, substance abuse, being in a socially maladjusted peer group, manipulation, excessive use of profanity, extreme testing of limits. Now, a lot of these can also be due to an underlying disability, right? So some of these can be ED type behaviors, but when we're looking at social maladjustment, we're looking at rule breaking behaviors. We're looking at more of a conduct disorder. Arguably, if a student's only diagnosis is conduct disorder, and if there's no other needs present, then that would be a social maladjustment and likely not qualify. But I think in reality, that's doesn't happen very often. I think in reality, most of our students with conduct disorder probably have other needs, maybe other diagnoses in addition to the conduct disorder. That's ultimately up to the CSE to figure out, and you do that through your evaluation. According to that research, students with ED are not likely to demonstrate concerns that include significant disruptive behavior, antisocial behaviors, or socially inappropriate behaviors. I disagree with this. I think lots of kids with ED have significantly disruptive behaviors and socially inappropriate. I think we see that a lot for students with ED. Again, that line, it's not a bright line rule. It can be difficult to determine, but definitely antisocial behaviors are likely not an underlying emotional disability. And then a student who is socially maladjusted could still meet criteria for a different classification, any of the classifications. And again, that's for the CSE to determine, even if they're socially maladjusted. So what I want you to walk away with is you should identify if there's social maladjustment, but if there is, it doesn't end there, the analysis. You have to continue that analysis to see if, in addition to that social maladjustment, there is an underlying disability that warrants classification. We're going to talk about some case law. A lot of these cases around emotional disability involve parents unilaterally placing their child in a non-public school and then initiating due process to request that the district pays the tuition of that non-public school. And in these situations, these are the highest stakes situations for special education due process because these private schools, which include residentials, are very expensive. So I'm seeing now hearing requests where private school tuition is $250,000 a year. And it is not reimbursable by the state in that situation. So these are huge issues. If you hear about a student being placed in a residential program, it's really important that you consider if that's a gen ed student that you refer them to CSE. Because even if you find them ineligible, at least you've met your child find obligation of going through that process. And if they do have an IEP, that you convene the CSE to make sure that the IEP is everything that it should be, because that would be what you'd have to defend. Now, parents are supposed to give us notice. They're either supposed to tell us at a CSE meeting or give us written notice and say, I disagree with the IEP provided by the district and I'm reserving my right to obtain tuition reimbursement, or I will be initiating due process or something like that. If that happens, that's when you should call us, because that's when we need to talk about what we do to place the district in a good position to defend. If that is said to you verbally at a CSE meeting, don't end that CSE until you make sure that IEP is the best IEP you could possibly provide, because that is the IEP that would be defended. If they do it in writing, you have 10 days to reconvene the CSE, so you kind of get a second bite at the apple. But if they say it verbally at a CSE, then you don't have that option. So when a parent unilaterally places their child at a non-public school, at a private school, in order to be awarded tuition reimbursement, they have to win on three things. Number one, the district is unable to prove that it provided the student a free appropriate public education, or that it offered the student a free appropriate public education. That's the most important prong. That if we lose that prong, it's really hard to win. The second prong is the parents have to prove that their private placement is appropriate. They usually win that. That's a really low bar. And the third prong is the parents have to prove that the equities favor them, which means that they participated in the CSE process. Also a really low bar. So that FAPE issue is very important. And if a parent brings us to due process and says, my kid should have had the ED classification and we didn't even evaluate or classify the student, we would have to prove that that student is not eligible for an IEP. Because if the student is eligible for an IEP, we automatically lose because we haven't offered a FAPE because we haven't classified them. So again, when in doubt, refer to CSE. It's much easier to prove that they didn't need the IEP if we went through the evaluation process and we found them ineligible. If we haven't gone through that process, we don't have much to prove or to rely on that they don't need that IEP. All right, so in this first case, that we're going to talk about, a student was in a private general education school and got kicked out of that school, and the parents enrolled him in public school for a short period of time, and then they pulled him out and they put him in a private school, a therapeutic school, and they initiated due process for tuition reimbursement for that therapeutic school. And the student had criminal charges against him for property destruction, had engaged in a lot of rule-breaking behavior. When he was in 10th grade for a very short period of time, he showed some depressive symptoms. but it just appeared in 10th grade and it didn't last for a very long period of time. So the finding, the Southern District of New York here found that the student was not eligible for an ED classification because of the previous minor depressive episode, because it wasn't significant enough, it didn't happen over a long period of time, and that the student's behaviors of drug and alcohol abuse, truancy, defiance, and refusing to participate in school were based on social maladjustment without an independent emotional disability. So the district prevailed in proving that the student was not eligible for an IEP, and so the parents were not entitled to tuition reimbursement. A nice decision for that district. Some other cases, not in New York. I think it's getting to be that time, guys, right? Might need some cheaters. Okay, so for this first case, parents unilaterally placed a student, initiated due process before the district was able to do their evaluation. They were going to refer and they were about to do the eval, and then the parents placed the student. The student had a history of academic, behavioral problems, legal problems, but achievement tests showed that the student was making academic progress. And the court in this case held that the student was not eligible for ED classification because the student was socially maladjusted. The needs that the student presented with were stealing, skipping school, using drugs and alcohol, but continued to perform well on standardized tests. So all of the student's behavioral needs were attributed to rule-breaking behavior, social maladjustment, ineligible for ED. For this second case, a student had diagnosis of PTSD, depression, and ODD. She had difficulty attending school. She was placed on homebound instruction. And the ruling was that the student was socially maladjusted, could also qualify for ED classification if she met the other criteria set forth in the regulation. So even though she was frequently truant and had work refusal, she met classification criteria because she displayed a general pervasive mood of unhappiness or depression. And the court held in this case that major depression, and not just her misconduct and manipulation, underlay her difficulties at school. So this is an example of a student who had both, and so she was eligible for ED. All right, this other first bullet here, a student had a diagnosis of conduct disorder, bipolar disorder, and ADHD. And since the 5th grade, the student had numerous suspensions for threats, made suicidal comments, performed poorly on tests. And the parent said that the student should meet criteria for an ED classification. Actually, the court found the student met criteria for an OHI classification. So that's a typo in that first bullet. So the court said the student had bipolar disorder and multiple disciplinary referrals due to aggression and insubordination, and was eligible for an OHI classification because the student also had ADHD that impacted educational performance. And that's in this next case, a student had anxiety and acute stress disorder, not a diagnosis that I see. You usually see PTSD. The student also had school refusal, work avoidance, poor academic performance, and indicated an inability to learn. The student also had an inability to develop positive relationships and a pervasive mood of unhappiness and depression. So met 3 of those, and of those criteria that we talked about. And the SRO found that the student qualified for ED classification, even though the student was socially maladjusted, because the student had all those other symptoms associated with. Questions about ED?
Would you suggest that in like the PWN that we capture if we're determining just socially maladjusted behaviors separate from an emotional disability, use that language?
Yeah, so the question is in the PWN, should we say if the decision is that it's only due to social maladjustment, so no classification of ED, should we capture that PWN? Yes, you should, and you should explicitly say why. I would highlight what the behaviors are and say these are social maladjustment. The student does not meet any of the 5 criteria for ED. All right, let's talk about OHI. The OHI classification is so weird, isn't it? It's a weird classification, having limited strength, vitality, or alertness, including a heightened alertness to an environmental stimuli that results in limited alertness with respect to the educational environment. I don't know where they came up with that. And usually, the most frequent time we see OHI is really for ADHD, right? And a lot of times those kids are real alert, right? But we're going to break down how the federal government has said that even ADHD falls under this criteria. So again, within that criteria, it has to be due to a chronic or acute health problem. And it could be things like asthma, ADHD, diabetes, epilepsy, etc. That's not an exhaustive list. So, and a lot of people say, well, doesn't this mean we need to diagnose it? Well, no. Obviously, diabetes is a medical diagnosis. We probably know if a student has diabetes. But if it's something like ADHD or anxiety, that's something that we should be uncovering through our evaluation. And again, we don't have to diagnose. We can determine that the student has symptoms consistent with that type of diagnosis, and we do that through our evaluation. And then it has to adversely affect the child's educational progress. The Federal Department of Education has opined that the limitation on strength, vitality, and alertness does not need to be the result of a physical health problem, and it could include mental health needs. This is one of the reasons that a lot of students, most students who qualify under ED might also qualify under OHI. And also a student with ADHD may be eligible for classification under OHI if the condition limits the child's alertness to the educational environment in a way that adversely affects educational performance. So here, the Department of Education is saying, if they're so inattentive that they're not alert to the instruction, and so that limits their academic performance, or if they're so impulsive, they're not alert to the instruction in a way that limits their academic performance, that would be an OHI eligible situation. There has been some questioning with the Department of Education if they would have a separate classification for ADHD, and they've said no, OHI is sufficient. So that's why we have OHI. And you might have a lot of students who have a chronic health condition who don't need special education, but they might need accommodations under Section 504. So I just want to throw that out there. And if a student has significant needs regarding a medical need or a medical disability, like through the nurse or through a health plan or something, it's probably a good idea for them to have a Section 504 plan. And you might even have a Section 504 plan where the only accommodation is an individual health plan, and that's okay. So how do we determine if it adversely affects students' performance? The CSE ultimately has to determine that based on the evaluation. Obviously, adverse means some type of significant impact in school. A lot of times we hear about significant impacts at home that we don't see at school. That can get tough, especially if it's with homework, right? But really we rely more on what are we seeing in school, knowing that we also have to consider what parents are reporting happens at home. And an effect between the two means there's some kind of connection, that disability is causing that adverse impact, and then the educational performance, again, we're looking at beyond just achievement. We're looking at how the student is doing in school as a whole student. Now, in this first case, there was a student who had ADHD and anxiety, which seems to be so many of our students these days are really struggling with that. And everybody agreed that the student had those diagnoses. The district and the parents agreed the student had those needs. But the issue was whether there was an adverse impact, whether those were causing the student to need special education because of those diagnoses. And the holding was that the student was able to participate in the general education environment without an adverse effect on educational performance. So here the SRO said, no, the student does not meet criteria for OHI because there is no adverse impact. And then the SRO even went farther and said, even if there was an adverse impact, they wouldn't by reason thereof need special ed and related services. Remember those two prongs we talked about at the beginning. So the student had the diagnoses but didn't need special education. And the reason for that was because the student was performing in the average range, meeting or exceeding expectations in all core subject areas. And there was no educational impact on educational performance because the student demonstrated achievement scores and report card grades in the average range, didn't show any sign of anxiety during a classroom observation, progressed socially and didn't have any social needs, they had a psychiatrist, the parents who testified that the student would have increased anxiety and work avoidance when academic pressures increased, but the district presented evidence that that was not true and that was not evident for her. The student gained strategies to cope with anxiety when provided with explicit instruction from her teachers, and there was no adverse social emotional functioning because she was friendly, respectful, compliant, and had a good sense of humor. This was a district that was very well prepared. They had a lot of evidence and information to demonstrate that the student did not qualify. In this other case, this was a parent request for tuition reimbursement. The student had diabetes, celiac disease, hypothyroidism, and the ruling was that the student did not qualify for an OHI classification, despite relative weaknesses in reading comprehension and recalling information, because her overall academic performance was satisfactory. And one of the things that the SRO highlighted in this case was that all of these medical conditions were well controlled with medication. And so she was coming to school and performing well. They weren't impacting her in school. Now, by the way, for 504, medication is a mitigating factor. So if we're looking at 504 eligibility, we can't say, well, when she's medicated, she's doing fine. We essentially have to figure out if she's not medicated, would she need 504 accommodations? And if the answer is yes, then we would give a 504 plan. Just want to throw that out there. All right, and just like for ED, there's an expanded definition of educational performance when we're looking at underlying need for an OHI classification. So strong academic skills and passing from grade to grade are not the only factor. We have to take a broader approach, looking beyond grades such as attendance, homework, and organization. Also feedback from teachers and standardized test scores. The Office of Special Education Programs with the Federal Department of Education has said that students with high cognition and ADHD could still qualify for OHI to address a lack of organization skills, homework completion, and classroom behavior. This is why our evaluation is really important. We have to evaluate in all areas of suspected disability. I've had some questions like, why would we give a brief if we know a student has an ADHD diagnosis? We know they have it, there's no point in giving the brief. But what something like the brief would do is give you some standardized information about how the student is performing compared to their peers, with how those symptoms of ADHD are looking within the school setting, and if they're having a significant impact or not. That's why we still need to collect all of that data, even if we already know that there's an underlying disability. All right, and I kind of started with this. Classification does not drive services. So again, classification just opens the door, not the hill to die on. Plenty of students would meet criteria for more than one classification. Obviously, they have to actually meet the criteria. You shouldn't just choose a classification that they aren't eligible for. But if they meet more than one, it's okay. If you choose the one that maybe the parents feel more comfortable with, that's okay. The only time classification makes a difference is with autism. There is a separate provision under Part 200 of the regulations related to autism, where students with that classification are entitled to certain things automatically. One example of that is parent counseling and training on the IEP. There's some other things that students with autism are automatically qualified for. But again, that doesn't mean that you have to put them under the autism classification if they meet some other classification criteria. And you can give parent counseling and training regardless of the classification. So it's the students presenting needs that drive the present levels of performance, which drive the goals, which drive the programs and services. It doesn't matter what you call it. There's plenty of students with a learning disability classification that have all maybe behavioral and social emotional needs. As long as the IEP addresses those needs, that's what's most important. Questions? All right, I'm going to give it to Jeff to finish.
Bonus.
Oh, bonus. Okay, so you might have heard, remember, there was that case out in Connecticut in the Second Circuit that said students are entitled to a FAPE until they turn 22 or earn a high school diploma, whichever happens first. Remember that? And then the New York State Education Department came out and said, hey guys, we think this applies to us because it was a Second Circuit and we're in the Second Circuit. So students are now entitled to a FAPE until they turn 22 or earn a high school diploma, which was an increase from the end of the school year in which they turned 21. And then the state told us that they'd really like us to keep them through that school year that they turn 22, but we're not required to. We just have to keep them until they turn 22. And that gives a lot of confusion about what do we do. That certification only goes up to that age, and we're not really only goes through 21. So now we have teachers who are not certified for students who are 22, right? A lot of confusion. Legally obligated up until they turn 22. Well, there was a case in Albany, you might have heard about it, where some judge in Albany was like, no, I disagree. The law says 21. And I think that's probably going to be reversed. But the state ed department came out and said, yep, we know about that case. Too bad, still until they turn 22. And we'd like you to continue through the end of the school year in which they turn 22. So I just wanted to let you know that from state ed standpoint, despite that case in Albany, we're still at 22. Yes.
I have one question going back to, actually ADHD.
Sure.
How heavily should the CSE take into consideration when parents express that their child is only successful because of the support they're providing at home?
So the question is, if a student has ADHD, how much consideration should we take into account when parents say they're only successful because of the support provided at home? Evaluative data is so important, and we have to consider input from the parents. But if we have a lot of input and a lot of data from school that says, no, they're doing fine, then you probably have a strong basis to say no. I always think it's a little risky when parents say they are working on homework for 6 hours every afternoon. To me, that could blur into the line of an educational impact, right? But I'm not saying automatically it does, but the more information that you have to help support the decision, the better off you are. Yeah.
And before we move on to the other topic too, you briefly touched on this, but I think it bears repeating that also look at what services you are providing to the kid as well, because some of those, even though they're not technically within the continuum, may start to look like continuum services. So if you are providing something that looks like a continuum service to a kid and then trying to simultaneously maintain that they shouldn't be classified, that's not a great position to be in either.
Yes. That's a good point. The building level services. Yeah. So building level through RTI or MTSS. What I find, and we've talked about this a lot, right? What I find is that for behavioral and social emotional needs in general, districts are using them for way too long at way too high a level of intervention. And that it's essentially an IEP level of support provided through gen ed. And so, yeah, I think that's a good point, that if we are giving the kid a significant amount of support outside of special education, and that's been over a long period of time and to a marked degree, that we probably should consider referral and classification situation.
Okay, last topic. It's a good one. Get ready. So these are good materials. This consent, everything you possibly need to know about consent is in these slides. So I'm going to suggest, as you always do, print these out, keep them, because this is about issue spotting. Because we're going to go through a lot of rules, a lot of scenarios, and it's very important that we pay attention to exactly what we're talking about, whether it's revoke or initial or evaluation or services or 504 or IEP. There's lots of scenarios, and we're going to go through a lot of them. So we all know that the gateway to the CSE is through an evaluation, an initial evaluation, not a reevaluation, an initial evaluation. And we're required to conduct an initial evaluation before we can determine classification. There's a couple of timelines for initial evaluation. Upon consent, receipt of consent from the parent, you have 60 calendar days to finish the evaluation, and you have 60 school days to have convene the CSE and get the IEP up and running. So it's essentially a 2 and a 3 month deadline. Now, if the parent is slow to produce the child for the evaluation, the 60 calendar day deadline to evaluate can get pushed back. But you can't push it back beyond 60 school days. That's because that's the ultimate timeline. So that's the first rule. Is that 60 calendars can get pushed back a little bit. We have some wiggle room, but only so far. How does the district initiate the evaluation process? We all know that. We send a written notice with a consent form, and we describe what the parent is consenting to in the initial evaluation, informed written consent. If the district wishes to evaluate the student, must it seek parental consent? Yes, of course. I'm sure we all know that in this room. What if the parent does not provide consent for initial evaluation? So somebody referred the student, we send a consent form, parent didn't send it back. What do we do? Well, if that happens, we're supposed to reach out to the parent and have a conference and say, what are you doing? We need your consent. You got nothing to lose. Let us test. If, if, if we don't convince them to sign, we have another option. We could initiate an impartial hearing to override the parent's refusal to consent to the evaluation. You don't have to do this. It rarely happens. It's costly. No one likes to initiate litigation. You probably don't have insurance coverage for it. And you need Board of Ed approval to initiate this. But despite all that, you can, if you want, initiate a hearing to override a parent's refusal to consent to the evaluation. Again, rarely happens. Has anyone ever done this? Yeah, you did. Yeah. Pretty unusual. Pretty unusual. So, now, reevaluate. Oh, question.
You're not intended to comfortable to give parent a period of time, you know, what we've done before after the if we don't hear from you by this date, we will assume that you do not.
Yep.
Because otherwise, how long do you let it stay out there if you're not interested in initiating the process?
It's a good point. And there's no guideline on that. We have to have that conference relatively quickly, within like a month. And after that, you know, it's vague. You don't want to sit on it too long. You don't want to sit on it too long. Reevaluation is a different rule. Reevaluation is, you know, every 3 years, perhaps, unless if needed, you determine what subsequent testing you need. You send out a parent consent form. There's a couple of options. They could sign it. You're good to go. They could write back or say, hell no, I'm not doing this. I mean, you don't want that, but at least you know what to do. Then you got this strange area of no response. No objection, it's just silence. If for a reeval, not for an initial, if you get silence, after multiple attempts, you can proceed without parental consent. You don't have to do it, but you can do it. There's no procedures on what you're supposed to do. In that regard, practical tips. You need reasonable efforts. You can't just send it once, wait a day, say you didn't respond, so I'm going to do it anyway. You need multiple attempts. You need reasonable efforts to obtain consent for reeval. That means multiple attempts. Ideally, some letter saying, please sign this, we need you. Maybe a phone call. Maybe go to their house. Maybe the regs, the commentary contemplates, go to their house. Go to their work and say, please sign this. But you need to document your attempts. And this isn't written anywhere, but if you're going to do this based on the silent approach, you could also write them a letter saying, we haven't heard from you. We're going to go forward on this day. This couldn't hurt. A lot of evaluators don't like to do this, which, so question, yeah. Same. It's part of the reeval, so the same rule would apply. Although this is a strange rule that FBAs aren't really evals, which is a whole other story. But yeah. Question? Okay. So if you propose a reevaluation and you send consent, and you list what's going to be in the reeval, the FBA is in there along with OTPT, whatever you name it, and they do not respond, and you make multiple efforts to get them to sign it, and they do not respond, they say nothing, then you could proceed with the reeval. You don't have to, but you can. Yeah, it does. You could call it an initial. It doesn't matter. The fact is, that doesn't matter. Initial eval is pre-classification. So I like your thinking. I like it. I like your thinking, but it's the question. Yeah.
If you have parents who are divorced,
Yeah.
custody,
Yeah.
and one parent is in favor of the initial and the other do not.
Okay, so you got, so first we're gonna say, let me see the order, because, and some, if maybe it says they have to agree, maybe it doesn't, maybe it says they both, but if it's joint custody, so I assume they have joint custody, this is, okay, so we know with joint custody, there's different perspectives on this. One is, I mean, it ultimately, either they have to agree or nothing happens, but if you go with they each have individual rights, one could consent and one could revoke, and then you're in gridlock. If you get gridlock, you tell the parents that I'm gonna call your law guardian, and I'm gonna tell your law guardian, you need to intervene, because we can't have gridlock. And usually, sometimes that works. The school cannot contact the court. They don't have standing, but the law guardian can. And when the law guardian hears that we have gridlock, law guardian might make an application to the court to give one parent the right. And that usually gets people to agree, but those are tough. Question, you want to comment?
There is a really old, so I don't know how authoritative it is anymore, but there is a very old OSEP memo that does say that consent of one parent with joint custody is sufficient to initiate evaluation,
Okay,
but that both parents' consent is necessary. for
Right,
initiating
right.
the services.
right, and that's it, yeah. The problem, right, the problem with the one, the other could just revoke it. Yeah, so and there was a decision years ago saying if one parent has custody, sole custody, then they're the decision maker. So, oh, good, but thank you. Okay, so, so we just talked about like overriding consent for refusing to evaluate. There's a special rule. You know, the kids with IESPs, they're in a non-pub or they're in home instruction, they get special ed services too. There's this rule that says we cannot override their refusal to consent. So that's a great, if you're at a party and you're really bored, you could give that nugget of information. But that exists. It's a strange rule, but there it is. Can a parent revoke a consent to evaluate? Okay, just so we're clear. This is an evaluation. This is parent says, yeah, please, it's okay to evaluate. Maybe it's a reeval. Maybe it's a initial. They consented. Can they revoke it? Common sense would say, sure, it's America, you can. We know they could revoke services. We'll talk about in a second. There's nothing in the regs that recognizes the right to revoke a reevaluation. Isn't that bizarre? It does not exist. So what do you do if that happens? You could say too bad, or I mean the most logical outcome if that happens, because a lot of times then they'll refuse to produce the kid at that point. It can get ugly. But what do you do procedurally at that point? There are two logical options. You could view the parent's conduct as a withdrawal of the referral, which is weird because which would make more sense before they consented, or you could proceed with the CSC meeting without any evaluative data classified. Or you could really take the high road and say, I'm doing this because you objected once. But it's a hole in the law. And I don't know if anyone's ever seen this situation before, but I think the cleanest thing is just to call it a withdrawal of the referral. But again, it's a strange area. This is the most bizarre part of this program right here. But what if, here's another one, what if a parent attempts to revoke consent after the evaluation takes place? This happens. They don't like the evaluation before it. They go, too bad. There's nothing in the rules that allow this either. There's something in criminal law called the fruit of the poisonous tree. Like if you give a admission of guilt, but you weren't read your Miranda rights, the parent could say, ignore that, ignore that confession. There's no rule like that in special ed. So if you conduct the evaluation, you just proceed with it, even over the parent's objection. You don't just ignore it, because now you're on notice of it. You did it. If the parent objects to the evaluation results, I mean, keep asking why there might be a valid ground on which they're objecting. But it's pretty much too late at that point. So again, focus on when, so if they revoke consent to evaluate before the evaluation, maybe a little wiggle room, but no wiggle room after the evaluation is done. Okay, parental consent for services. So we've done the evaluation, you got the consent, you convene the CSE, you find the student eligible, you need consent for services. You need consent to implement the IEP. Have to get it. So, without parental consent, if the parent refuses to provide consent, we can't provide the IEP. We can't implement the IEP, and we can't be found in violation of our obligations either. Even though the parent consented to the initial evaluation, that's not to be construed as consent to implement the IEP. You need the second consent. Now here, if the parent refuses to consent to the initial evaluation, you cannot initiate a hearing to override their refusal. There's nothing you could do at that point, except call CPS and say, hey, you know what they're doing? And sometimes CPS will intervene, sometimes they won't. If it's a very disabled student, severely disabled, you might say, what are you doing, parent? Maybe they will, maybe they won't. But you cannot override that refusal. We're going to talk a little bit about what's plan B in that case. But if they don't consent, then you're off the hook. They can't come back and say child fine obligations or so on. They're not entitled to anything. Now, one more. Let's say they consented to the IEP and you're cruising along and you're implementing IEP year after year after year, and the parent says, I changed my mind. Can I revoke consent for services? You can revoke. Now, years ago, you couldn't. So this is kind of mind-blowing. But you can. And so the parent may revoke consent in writing at any time. Just for services. Now, got to be in writing, and there's a process for this. But if they do it right, there's nothing we can do. We can't override this. We cannot provide special ed services at that point. If they revoke consent for services, we can't override it, and we're not going to be found in violation of our FAPE obligations. So this happens. Now, this is not a declassification. Do not call this a declassification, because we never declassified a student. According to our records, you're eligible, you just didn't let us do it. So do not call it a declassification. Now, you have to send written notice to the parents. This is a rule. If they send you saying, I'm revoking consent for service, you have to send them a prior written notice letter setting forth the consequences of their decision. You say, by this date, so you pick a couple of days later, let's say you get it on a Monday, say by next Monday, we're going to stop implementing this IEP. And then here are the consequences of this. Now, they're good sample letters on Frontline on what to say, but you're allowed to individualize this letter. Obviously, it should say you don't get any more nexus rights, especially if this is a kid with behavior issues. That should be the first thing in the letter. But you can put other stuff in, like what if it's an athlete? And what if you have a no pass, no play rule in your district? You might want to say, without these services, you might not pass. And if you fail, you can't play. You tell them everything. You communicate. It's your chance to individualize that letter to their consequences. But you have to put the end date, and then you stop. There's nothing you can do to override it. After the student, again, they're not presumed to have a disability for discipline purposes. If the student parents change their mind often, like, let's say a week later, they go, oops, that was a bad decision, I'm gonna re-refer. Well, we're starting from scratch. It's an initial evaluation. Now you have flexibility when you determine the scope of the evaluation. Say we just evaluated you a year ago, we don't have to do all that testing, but you don't have to. Now, sometimes, you know what prompts the student to get re-referred? The kid gets suspended. And they go, oh, I don't get those nexus rights, so I'm gonna re-refer. Well, if you're referred while suspended, the rules say the evaluation has to be expedited. So it's 15 school days to evaluate and 5 more school days to convene a CSE. So they won't have an IEP for at least 4 weeks. And there's a strange rule that says if you're re-referred while you're suspended, and if you're classified, you're entitled to the protections under Part 201. No one knows if that means so you get a Nexus meeting late or not. That's open for interpretation. But if you take the interpretation that you are entitled to Nexus after you're reclassified, well, you're going to be suspended for at least 4 or 5 weeks. So that's a bad decision, but that's the breaks. And that's why they shouldn't make these decisions lightly. Parental consent. Oh, question. Okay.
You have a reevaluation of the behavior assessment, you know, it's
Yep.
If the parent explicitly refuses that,
Yeah.
what is kind of the recourse, the next step if you're in an impasse?
Well, if they expressly say no,
Yeah.
they object to it. I mean, try to come up with behavioral strategies. Try to come up. It's weird. Come up with a BIP without an FBA. It's not ideal, but do the best you can with what you have, with observations and so on. Any thoughts on that?
There are a couple of cases that say that if family either denies outright consent for a reeval or places so many restrictions.
That's my next topic. Yeah,
Oh,
that's my yeah.
Recourse.
Yeah. But ultimately, but they're not consenting at that point. So you just come up with other behavioral plans without an FBA, just based on info. See, there is rules. There's some people say that FBA doesn't require consent. There was a decision that said that. So the problem with asking, if you're in a district that asks for consent and they don't give it to you, it's we didn't need it anyway. It's a bad look. So just come up with a BIP. They can't, no one's going to challenge. They're going to have a hard time challenging the BIP on the grounds that, well, you didn't do an FBA. If you're going to have to go on observations and experience.
Would it have to be classified as something else? Because those numbers the BIP have to be based.
I know. What would you, just curious, what would you like, how would you like to handle? I'm sure, like, not.
I don't know.
Right, yeah. Because
my concern for it absolutely keeps on learning, but it wasn't so pervasive that it was going to immediately cause an injury to both self or others. But my concern is more of a situation that directly implies that, because then to not create the functional supports that the regs outline isn't providing them for the safety, but I can't do that functionally in evidence-based, which doesn't really allow you to have.
it's going to be it might be a weaker bit, but it's like we just got to do the best we can with what we have. It's rough. And if somebody challenges the appropriateness of it, would say, well, what do you want? Like, we're here because of you, but no, great question. And a frustrating question. Okay. So parental consent for 504. The 504 reg, there's nothing in the 504 regs that expressly says that you need consent for an evaluation of services, but OCR has said you need them. So you need consent to evaluate under 504, and you need consent to implement a 504 plan. Parental withdrawal of consent for 504, presumably the same applies. If you could withdraw from an IEP, you can withdraw for 504 plan. Partial consent. Is partial consent for an evaluation allowed? So we're clear. District, you send out a beautiful prior written notice consent form saying, we want to do Johnny's initial evaluation. We want to do A, B, C, D, and E. And the parent says, thank you, I'm crossing out A, crossing out B, I'm gonna cross out F and C, I'm gonna add in X, Y, and Z, and I'm gonna sign this. So go for it. Is that consent? No. We take the parents' input while formulating the scope of the evaluation, but whatever we propose, they don't pick and choose. It's all or nothing. And so if they want to go that route on an initial, our position is you didn't consent, you get nothing. Hopefully you can work it out. But the parent, but remember when we start saying, well, I want to do what's best for Johnny, so I'm going to work with his parents, that could lead to bad outcomes. You have the right to say, this is what we propose. If you don't like it, you can have an IEP afterwards. Yep.
Jeff, same thing with, and I think that the point was made in that exact case that you have on the screen. Same thing with parents that say, well, I'll consent to eval, but I want to pick the evaluator.
Yeah.
I don't like that.
Yep.
It's like, I want you to use this one, or I want you to use
Yep.
my independent. And I think the other point there was, I've had some really kooky parents that say, well, I will only consent if I can be physically present.
And that's it, yeah.
Same thing, because Ann is a bigger expert on this, but what I've always been told by the school psychologist is, no, that's not consistent with the way
Right.
that this is supposed
Right.
to be administered.
Right.
You're not required to administer your testing in a manner that complies with what the parent wants. That is a constructive.
Exactly. And I like when the parent wants to be present, it's always helpful when we prompt the evaluator to say, the parent's presence will impact this, right? And they say, yeah, so that helps us. Go ahead. Yes. Yeah. Question?
Not a full evaluation, though the parent writes in a formal letter that they suspect, say, dyslexia, therefore want 10 other assessments done, including repeat assessments from assessments that were done a year ago, and then ask Ryan, please consider my signature on the bottom of this letter to be consent and procedures.
Thank you. Okay, great. So this happens. Parent writes a referral letter. I'm referring Johnny and I want X, Y, and Z evals. I'm consenting to it. That's not consent. And we had a CEQA decision. We prevailed on that. The parents give him, there's a process for determining the scope of an initial and a reeval. And it's this bizarre metaphysical team meeting without a team, but you need input from the parents. So if the parent asks for something and we don't put it in, it's possible they challenge the appropriateness of the eval. So we say it, we reject it at our own risk, but we can reject it. They also have a right to an IEE afterwards, the whole other process. But that is not consent. Writing a letter requesting something, consenting is not. Yeah.
On that, the PWN, so it could be, you could put your rationale for rejection, right? He has determined that the evaluation based on the parent input. And then my second question is, because it's a re-evaluation practice, and students already have the IMP, what type of timeline are we looking at for that?
For the request.
Still, the evaluation that is
So initiated by the district? The time?
the parent is asking for a reevaluation, but new evaluations, the students already classified, what responsibility does the district have for the timeline of that?
It's a strange, there's like, the regs are strange. It deals with like the timeline for a reeval is not based on consent because you don't always get consent for reeval. So it's based on this concept of like request for referral. There's some strange term which nobody knows what that means. But I would say if a parent asks for something and that starts the process, I arguably you have 60 days to get the ball moving on that, to get it done. So nobody knows, and I'm not fully following. Like if they're asking for a reeval, there's no time frame for that. That strange meeting. If you look in the section, what contemplates like members of the CSE meeting but not meeting, But I would try to do I would look to do it hopefully within 60 calendar days of that correspondence. But it's tough because you might have to ask consent multiple times and they may or may not respond to it. So I wish I had better news. Okay, so partial consent. What about partial consent for special ed services? We have a question.
Back to, evaluations. So recently we've had some families on consent to evaluate, writing in some additional pieces they think they would like about. Maybe we weren't initially recommending that. We have been moving forward with it. It's kind of going with the idea of not the hill to die on,
Okay.
but like,
Well-
maybe for some of maybe we talk about.
Well, ideally, in a perfect world, I always ask, what is the process for generating that letter saying, here's our proposed evaluation? Who determines what we want to do, including our evaluation? And ideally, or we should be asking the parent at that point, what do you want? So if we didn't do it initially and they sort of said, hey, can you add this? I'm more comfortable with adding something than taking out what we're not doing. But those are judgment calls. Now we could say no, you're not consenting, but their possible rebuttal is I'm challenging the sufficiency of this proposed evaluation because it didn't include certain things. So, okay, partial consent for services. We have an IEP, got a lot of stuff in there, and parent says, I'm consenting to some but not all. Is that okay? Or a parent revokes consent for some but not all. Is that okay? The answer is no. Parent doesn't have the right to partial consent. Now the caveat is the federal guidance says, well, if the parent's objecting to something that's not needed for a FAPE, then it's okay for the district to agree to take it out. But my comment is, why would we put it in the first place if it wasn't needed for a FAPE? So yeah, if you find something that's not really needed for a FAPE, you can take it out. So, alternatively, okay. Yeah, the parent would have the right to, to bring a hearing request and say, I don't like what's in here, it's inappropriate, it's not needed. So just all risk assessment. Now does New York have, so again, I'm saying no partial consent for services. However, there's this section in the regs that says something strange. It says a school district may not use a parent's refusal to consent to one service or activity under paragraph 1 of the subdivision to deny the parent or child any other services, benefit, or activity of the district, except for the conditions under paragraph 1 of the subdivision. Wait a minute. What does that mean? It doesn't mean what you think it means. It doesn't mean you have partial consent. What this means is if a parent refuses consent for special ed, you can't deny them something else. You can't say, you can't go on the trip. You can't try out for the team. You can't go for the school play. That's what it's talking about. It's not talking about consent, partial consent for special ed services. Okay, one more on partial consent. We just talked about typical IEP services, and no partial consent. There's always some strange issues. What about kids with IESPs? Kids in non-pubs. Remember, they were removing themselves from this public school. Can these kids get partial consent? Request partial consent, invoke partial consent for IESP? Nobody knows. You could argue the answer is no. But one caveat is, remember, these kids have to request services by June 1st. Does the right to request change things? Nobody knows, but it could open the door to requesting some, but not all. Nobody knows. What about this strange group of kids, strange category of kids who are 5 or 6 years old. They're eligible to attend kindergarten, but they're not compulsory school age. There's a special rule just for these kids. Can they, and we're supposed to develop an IEP for these kids with services. We pick the location. You may or may not have heard this rule. One of this a hidden rule. Do these kids have the right? Do their parents have the right to ask for some, but not all? They're not compulsory. Does that matter? Nobody knows, but it's food for thought. What about extended school year? We recommend 5 extended school year services. Can they request some? Could nobody, I think there's a little more wiggle room with these kids historically. However, the people doing this for a while, remember, there used to be a rule where you needed consent for your initial ESY services. Remember that? That rule's gone. So does that mean ESY should be treated just like everything else? Maybe, arguably. But if a kid doesn't go to ESY, do we call CPS? So there's some open questions with these kids. Okay, almost done. Can a parent revoke consent for an IEP? They have an IEP. They're cruising along year after year after year, 5th grade, 6th grade, revoke consent for an IEP. Can they say, I'll have a 504 plan, please? What do you do then? Are they entitled to it? Now, 30 years ago, 25, 30 years ago, OCR said no. As Kate said before, if you fulfill your obligations under the IDEA, you fulfill your obligations under 504. So if you refuse an IEP, you can't demand 504. That's good, right? Except there are some cases that say the opposite. There are some that follow OCR, some don't. A little risky. However, we're seeing a line of cases and a principle of following. It's probably a good idea to give a 504 plan in this case if the student has a medical issue. So if a student has a learning disability and a seizure disorder, it's probably a good idea to have a 504 plan just for the seizure disorder. Now, remember, what's the big deal here? Remember, 504 kids get nexus rights. So if you're trying to be nice to the parent, if the kid has an 811 behavioral issues, parent revokes consent, and to be nice, you give a 504 plan, and you try to suspend the kid who's in a placement he shouldn't be in, he's going to get a nexus finding with 504, and you're going to have an untenable situation. So kind of keep that in mind. And then lastly, one more. Okay, I didn't put the slides in. What about the 504 student whose behaviors and needs escalate, and you refer to the CSE, and the parent doesn't consent to the CSE evaluation? Can you take away the 504 plans? Who knows? I've seen it happen where you make that threat, but so this is a whole strange world out there. So that's kind of it. We got through it all. Thank you. If you have any other questions, give us a call, contact us, and drive safe. Take care. We'll see you soon. Bye-bye.